Item number 1.
Lordship, in this particular case, I need help of my junior, and unfortunately, one of his family member that earlier occasion. So today I can not able to argue this matter.
Okay. So we feel that this matter needs a deliberation.
Yes. It will
So it should be fixed only on hearing day, not on motion day.
Lordship,
On the pair being made by Mr.
Lordship, G kata.
Learned Counsel for the petitioner,
Yes, Lordship.
and having not been opposed by Mr. Aisodore, Learned Advocate General for the State of Arunachal Pradesh, the matter stands adjourned to be listed on suggested date.
If it is a hearing day, my lord, in that case, can it be on 30th of April? It's a Thursday.
Okay. Okay.
May I please, my lord?
Yes.
My lord, I beg to mention item number 31 and 32 on behalf of Mr. Tony Pertin. Due to his family bereavement, he could not appear today. He has taken consent from the learned AG also.
31 and 33.
31 and 32.
32. He on the hearing matter.
Okay.
He has,
I understand their difficulties because his father-in-law passed away.
Yes.
But this may be noted down in next time this matter may be taken up because I am also getting a lot of pressure from government of India to dispose of. So
Okay.
efforts had been made on that particular day
Okay.
so date
to dispose of the matter. So which date?
first April.
1st of April.
He will be there on 1st of April.
1st of April.
Yes,
Okay.
Mr. Tony Pertin.
On the pair being made by Mr.
HK Jamo on behalf of Mr. T. Pertin.
Learned Counsel appearing on behalf of Mr. T. Pertin, Learned Conducting Counsel for the petitioner. The matter stands adjourned to be listed on 1st of April.
My lord, my submission may be noted down. That
And
efforts had been taken to dispose of the matter on 1st of April because I am getting a lot of pressure from Union of India.
Okay. No. We are fixing the matter on 1st of April.
Generally, I don't know what happened. It is all this is passed over for so many times. That is the reason I'm
Okay.
praying before your lordship.
Okay. Mr.
Why don't
Y. Dole, Learned Counsel for the respondent number.
Panel Counsel for Union of India, Senior Panel Counsel for Union of
Senior
India.
Panel Counsel for the Union of India, however, submits that
And efforts had been taken.
on that day endeavor may be made to dispose of the petition,
On
no,
first
to
of
give final consideration of the petition on that day.
highly obliged.
187 also same order. 186 and 187. Two matters, sir.
31 and
30.
31 and 30. Yes.
For the
With
matter.
my lord's
Yes,
permission,
Highly
may I mention item 12 and 13, my lords? My lords, for the same reason, I am also seeking adjournment for 3 weeks, my lords. There is a bereavement in the family of the learned. My lords, there is a bereavement in the family of my learned AOR, my lords, Mr. Thongwan. And I also wish to file my rejoinder affidavit to the counter, my lords. So therefore, I am praying for 3 weeks time, my lords.
My lord, there is, I have some objection in this case. For last time, your lordship let the matter come up. So far as the main writ petition is concerned, there is no objection. But there, in a contempt, we have filed a application before this honorable court for a direction because they have deposited the amount as per this honorable court's order. So we want that this contempt, so far as because we are suffering from 2018. And to circumvent the order of this court, they have filed a writ petition. I'll show
This is
before
on
this
merits, my lords. I will satisfy the
I will
contempt
show
is not
before this
maintainable
court.
at all. Today, on the
Okay,
ground
fine,
of
my lord.
bereavement, my lords, I am praying for
No.
3 weeks time, my lords.
AOR, my lord, AOR, my learned friend is on the last day he was there in this case. I also understand we
Please,
don't
my lords, I
object
am there.
because my learned friend was appearing in this case, AG was appearing. Raju
My
was
lord, the learned
appearing in this
SG is
case.
also appearing.
Please
Mr.
see-
Raju is also appearing.
Please see the order that has, let this matter come up, my lord. I will, if your lordship
Lord, so
wish that it
therefore,
should be
we want to
adjourned, then
file
your
a
lordship will
rejoinder
adjourn it.
affidavit. It is not an unusual
Rejoin
prayer, my
the-
lords.
My lord, rejoin the affidavit. I
And
have
this
no
is
objection.
contempt is
I
not
have no
maintainable.
objection.
Therefore, the my lords counter.
Okay.
We'll call the matter.
Yes, I'm deeply obliged.
My lords, today there is a difficulty, my lords. The learned SG has not been briefed because of this reason, my lords.
Maybe
So
we'll
and
call the
rejoin.
we'll call
Rejoinder
the
has
matter.
not been filed, my lords. My lords, kindly grant me
Maybe.
some time, at least a week's time, so that I can brief learned ASG.
Okay,
He has
we'll
been
call the
appearing in the matter. My
Please
lords,
listen to me. We will call
sorry,
the
my
matter.
lords.
Yes.
May I, Your
My
Lordship?
lords,
I beg to mention item number 16, 17, and 18, Your Lordship. This matter to be listed after 3 weeks.
16, 17, and 18.
Yes, Your Lordship.
Yes, you
I-
obtained consent from the others.
Yes, Your Lordship.
Ms. Pango, learned government advocate, with consent from the other side, press for listing this matter on
After 3 weeks, Your Lordship.
after 3 weeks. Fair allowed.
Obliged, Your Lordship.
Fair allowed.
May I seek your lordship indulgence to mention item number 3, my lord, this admission column, my lord. My lord, I have taken,
Let the matter come before the court, my lord. I want to make a submission. Number 3 only, my lord. So let the matter come, then we will make it.
Okay.
Item 3 only.
No, you were mentioning item number?
3, my lord, item number 3. I have some difficulties, my lord, so I need some accommodation. So I've requested both, my lord, Mr. Bordole and London Senior Counsel, my lord.
But let the file come.
Okay,
before your
okay,
lordship.
we'll call the matter.
Yes.
No issue,
We'll consider it.
my lord, no issue.
Lordship, I would like to mention item number 5, Your Lordship.
Yes.
Lordship, here we have to produce the records, Your Lordship, which has not come yet, Your Lordship. I've taken the consent of the petitioner, Your Lordship. Lordship, may I kindly take up this matter on 10th of April, Your Lordship.
Ms. Arbasar, learned counsel for the learned government advocate, with consent from the other side, press for listing the matter on 10th of April.
10th of April, Lordship.
As she has not received any instruction.
Records, Your Lordship.
She has not received a record. Fair allowed, recessal list the matter on 10th of April.
Obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 24, Lordship. This matter may be, Lordship, taken up after 2 weeks because the private respondent has filed their reply, Lordship. So after perusing of the reply, if required, I need to file some rejoinder. Lordship.
Okay. Mr. T. Goram, learned counsel for the petitioner, with consent from the other side, press for listing the matter after
2 weeks, Lordship.
after 2 weeks. As he needs some time to go through the affidavit in opposition.
Opposition filed by the private
Respondent
respondent.
Number
5, Lordship.
5. Respondent number 5. Fair allowed, recessal list the matter after 2 weeks.
Lordship, there is an interim order, Lord, that may be
Interim
continued.
order pass earlier shall continue.
Deeply apologize.
Your Lordship, I beg to mention item number 19 and 25. I'm appearing on behalf of N. Dangan, who is the conducting counsel for these 2 cases. She is the conducting counsel for the petitioners in item number 19 and for the respondents in 25.
Who is?
N. Dangan.
Okay.
She's out of station.
Okay. Mr. Your name, please?
J. Nino.
J. Nino, learned counsel appearing on behalf of Ms. N. Dangan, learned conducting counsel for the petitioner. With consent from the other side, press for listing the matter after
3 weeks.
3 weeks. Fair allowed.
And your Lordship, there is an interim order with in item number 19 which may be extended.
Interim order pass earlier shall continue. In item number 25, we take down Mr. So-and-so, learned counsel appearing on behalf of Ms. N. Dangan, learned conducting counsel for the respondent, with consent from the other side, press for listing the matter after 2 weeks.
3 weeks.
3 weeks. Fair allowed.
Much obliged.
Release the matter after 3 weeks.
May I, Lordship, I like to mention one WPC 429 of 2025. Kindly the listing for the day after tomorrow on 25th, on
In
Wednesday.
which column? Hearing column or admission column?
Admission.
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 May I, Your Lordship?
Yes.
Your Lordship, I'd beg to mention item number 21. The council is out of station.
Let it also come, my lord. Let it come. Normal course, my lord.
Okay. Okay.
Let it come.
Okay, we'll call the matter.
Item number 1.
May I please? My lord, here, the petitioner is challenging the, my lord, impugn order dated 6/2/2026, my lord, passed by the State Information Commissioner, directing the petitioner to furnish certain documents, my lord, pertaining to, my lord, that bank details financial transaction and some details of the, my lord, land acquired by the government, my lord, for the defense purpose, my lord. My lord, the petition,
Where it is mentioned that it was acquired for the defense purpose?
my lord, I am coming, my lord. My lord, kindly turn to page number 30, annexure 3, my lord. Page number 38, my lord. This is the decision was taken, my lord, at the state level by the government, my lord, why this land was required to be acquired by invoking urgency clause. My lord.
You
Page
come to
38.
annexure 4, the
But-
notification.
My lord, first page number 38, thereafter I will come to, my lord, annexure 4. 38, my lord. My lord, may I start from serial number 1? The review meeting is in regard to the proposed construction of Frontier Highway Red project in the state. It is a defense strategic road to connect the remote location of the state bordering international boundary with the country's main through road network, so and so, my lord. Then decision was taken, my lord, it will be acquired by invoking section 40 of the this act, my lord, 2013, my lord. Thereafter, my lord, this notification, my lord, 4, my lord. My lord, may I take, my lord, this page number 43, my lord? After column, my lord, we'll see this, may I read, my lord, this notification is made under provision of section 40, one of the right to fair so and so. Thereafter, my lord, may I take to page number for this 41, my lord. If I say it's this section 41, my lord, RTA Act section 40, my lord. Yeah. Oh, RTA. Sorry, lane. RTA ni. Oh, lane.
No, you come to annexure 8.
My lord, annexure 8.
Yes. The circular, which you have relied upon.
My lord, this is also I am relying, my lord. First, my lord, annexure 40, this section 40, my lord. Basically, this lane was acquired under this section 40, my lord. Invoking urgency
clause.
Clause 40, my lord, 1 and 2, my lord. Special powers in case of urgency to acquire lane in certain cases.
Yes.
In cases of urgency, whenever the appropriate government so directs, the collector, though no such award has been made,
No,
may
that's all right. Understood.
my lord, my lord.
You come to annexure 8.
Yes, my lord.
Whether this circular covers your case or not.
This circular, my lord, since, my lord, here, my lord, it is therefore instructed.
No, you.
I am relying on this circular also.
That's all right. You
I'm-
answer my query.
My lord.
Which clause of this circular covers your case?
My lord, here it is shall not share any sensitive government documents, paper, and not released for national security reason. Because this land acquired by invoking section 40, and section 40 has been invoked considering this, my lord, for the defense and national security. And once by invoking section 40, land was acquired, my lord. So this is for the purpose of national security and defense, my lord. That's why, my lord, this circular also saying that, my lord, any document or papers concerning to the national security reason should not be furnished, my lord. This is one ground, my lord.
No, that's all right. But which clause of this circular covers your case?
Here A and B is given, my lord. Thereafter at the below, my lord.
Whether the land was acquired for establishment of brigade or military base?
My lord, this is the road,
is
my lord. No, my lord, no.
Yes. Then land acquisition papers of the army establishment in the border area?
This is also, my
Not
lord,
for
not clear, my lord. It is for road only, my lord.
Then,
My lord, below it is written, my lord. It is therefore instructed DC and directors shall not share any sensitive government documents, paper, and not release for national security reason. And section 40, if I see, my lord, acquisition is for national security reason. And that is the understanding, my lord, that I am also, my lord, there is a binding direction not to disclose. This is one of the ground, my lord. My lord, another ground, my lord, there is a jurisdictional defect, my lord. As commissioner, my lord, without ensuring whether the first appeal, the applicant has exhausted the, my lord, statutory remedy, my lord. There is a bar under Rule 10 of the, my lord, RTI rules, my lord, which says, my lord, unless the commissioner satisfies himself that the statutory first appellate has been exhausted, my lord, the commissioner cannot directly, my lord, entertain the second appeal, my lord. And my lord, in this case, my lord, from the impugn order itself, my lord, may I take the impugn order, my lord?
Page number
Page number 28, my lord.
28.
28, I will read, my lord, 30, my lord. Straightly, I'll go to 30, my lord. May I read, my lord? At the middle, my lord, after 9, 10, serial, my lord. Records, however, does not disclose as to whether the appellant had approached the first appellate authority, the DC, under section 19(1) of the RTI Act, and whether or not the affair had considered the appeal so required, my lord. In the impugn order itself, my lord, commissioner has indicated that it's not sure whether this appellant has exhausted the first statutory remedy, my lord. My lord, section 10, rule 10 of the, my lord, RTI information rule says, my lord, the commission shall not consider, my lord, rule, right to information rules 2012. Rules. May I read them?
Yes.
The commission shall not consider an appeal, my lord, unless it is satisfied that the appellant has availed of all the remedies available to him under the Act, my lord. My lord, this here is a statutory completely bar, my lord. The wording is, my lord, shall not consider an appeal. The commissioner, before entertaining the second appeal, my lord, has to first ensure, my lord, whether the statutory, my lord, remedy has been exhausted or not, my lord. And here in this case, my lord, from the impugn order itself, my lord, it is reflected, my lord, that it's not sure. That examinations ought to have been done first, my lord, before entertaining the second appeal, my lord. This is another ground, my lord, that this also suffers, this order also suffers.
You see the finding recorded by the appellate authority.
My lord. 30, page number 30.
Yes. Record, however, does not disclose as to whether the appellant has approached the first appellate authority, the deputy commissioner, DC, under section
19(1) of the Act.
the RTI Act.
Yes.
Whether you have furnished the relevant papers before the appellate court.
My lord, I am
Appellate
not the appellant here in, my lord. I am the, my lord, PIO, public information officer, who has been directed to furnish the information. So the appellant is the private respondent here, my lord. Private respondent number 2 is the appellant, my lord. He filed the appeal, my lord. He files the appeal, straightly filing the second appeal, my lord, which is a bar, my lord. Therefore, my lord, the law says, my lord, rule says, my lord, it's very explicit, my lord, that the commissioner has to first ensure, my lord, that this statutory first remedy has to be exhausted, my lord. That has not been done in this case, my lord. Therefore, also, my lord, from jurisdictional aspect also, this impugn order suffers, my lord. Because first it has to be ensured that statutory remedy, whether it has been exhausted or not, my lord. There is a specific rules also, my lord. And some judgments also, my lord. Of course, I could not download High Court, Karnataka High Court says, my lord, that this is mandatory. First appeal has to be exhausted. Thereafter,
then, Mr. Sunar, you come with the judgment, we will take it up at 2 o'clock.
2 o'clock.
In the meantime, I will go through the rules.
My lord.
This made my senior Mr. Ashaki, who is standing counsel for the Information Commission. He's out of the station.
Maybe.
Just to
We'll take it up at 2 o'clock. Let him come with the judgments. Yes, next item.
Item number 2.
My place, Your Honor. Your Lordship, the present writ petition is filed under Article 2 to 6 of Constitution of India, Your Lordship, challenging the impugned notification dated 27 of February 2026, Your Lordship, wherein the post of the system management engineer has been disqualified, Your Lordship, and resulting to the termination of the petitioner, Your Lordship. Lordship, might kindly come to the page number.
But that notification has been stated in the WPC number 90 of 2026.
Yes, Lordship.
Right.
Notification was issued on 27 of February 2026, Your Lordship. Is in page number 19, Your Lordship. Your Lordship, may I kindly see?
This notification was stated by this court in WPC number.
Oh, yes.
WPC number 90 of 2026.
It was stay for law officer only, Your Lordship. There is 2% has been terminated. One is law officer and another is the SME, Your Lordship. And this WPC was filed by the Techi Poto, Your Lordship. By Techi Poto, the law officer, Your Lordship.
Law officer.
Yes. Same similar case, Your Lordship.
Okay. Heard, Mr. Your name, please?
Tigame, Your Lordship.
Learned counsel for the petitioner. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the notification dated 27 to 2026 issued by the Itanagar Municipal Corporation. Full stop. Notably, by the impugned notification dated so and so, the Itanagar Municipal Corporation has abruptly discontinued the post of system management engineer within bracket SME, resulting termination of the petitioner's contextual agreement despite extension of the validity of the same till 14/12/2026. The learned counsel for the petitioner submits that the notification was issued without giving any notice and affording an opportunity of being heard to the petitioner, and without assigning any reason. And as such, the same violates the principle of natural justice. He also pointed out that by the impugned notification dated so and so, the respondent authorities have terminated 2 persons from the post. One is the present petitioner and another is one, namely, what was the name?
Techi Poto.
Teki Poto, and by order dated 9/3/2026 in WPC number 90 of 2026, and this court was pleased to stay the said notification so far it relates to Teki Poto is concerned. And he also submits that the present petitioner is also similarly situated, and as a similar order may be passed in the present petition also. Having heard the submission of learned counsel for the petitioner, this court has carefully gone to the petition and the documents placed on record, and also far as the impugned notification dated 27 to 2026, and also the order passed by a coordinate bench of this court dated 9/3/2026 in WPC number 90 of 2026. It appears that by order dated 9/3/2026, a coordinate bench of this court was pleased to stay the operation of the aforesaid notification dated 27 to 2026. And also the notice dated 5/3/2026. Accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that notice be issued to the respondents, returnable in 4 weeks, step be taken by speed post and also by usual process within a week from today. List the matter after 2 weeks, and pending further consideration. The impugn notification dated so and so, so and so. So far it relates to the present petitioner is concerned, stands state as it appears that the same was passed without affording an opportunity of being heard to the present petitioner. And further, considering the fact that engagement of the petitioner was extended till 14/12/2026. This is the matter after 4 weeks, and also take this matter along with the WPC number 90 of 2026. List accordingly.
Much obliged.
Item number 3.
No, your lordship may peruse the last order. Last justice would you have an order? That's a ridiculous list. So my humble prayer is, my lord, government is taking everyday time, and this matter is serious matter as the petitioners also asked for. So we are also getting from the pressure to dispose of the matter.
My lord, I am sorry, my lord. My lord, if your lordship peruse the record, my lord, we have never sought, my lord. Perhaps this is my second prayer for lordship, my lord, asking for adjournment, my lord. Even we do feel, my lord, urgency is there, my lord. So matter is yet to be admitted. If your lordship is still in admission column, your lordship may admit the petition, my lord, and fix it for a hearing, admission hearing. That can be done, no issue, my lord.
Okay,
Yes.
okay.
Matter may be admitted and fix it for hearing.
Hearing, my lord, no issue.
I'm appealing for respondent number 1 to 4.
Heard Mr. Mao, learned counsel for the petitioner. Mr. Waidoloy, learned. In which capacity you are appearing?
I'm the senior panel counsel for Union of India.
Senior panel counsel for the Union of India.
For
Respondent
respondent number
1 to 4. Mr. R.S. Nabam, learned additional advocate general, Huda.
8 and 9.
Respondent number 8 and 9. Mr. Nabam, learned additional advocate general, price for listing the matter on which date?
My lord, will be okay, May 11, my lord. It's a hearing.
May
date,
11.
May 11.
May 11. Mr. Dolo, learned counsel for the respondent number 1 to 4, however, submits that the matter has not yet been admitted, and it may be admitted and the matter may be listed for hearing, as pleading has already been completed. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that both the counsel, the matter stands admitted, and raises a list the matter for hearing on
11th of
11th of May.
May.
11th of May. On which an endeavor will be made to finally hear and dispose of the matter.
Item number 4.
May it please your lordship. My lord, this also is an admission hearing. Here, the entire issue, my lord, surrounds under section 64, my lord, of the right of fair compensation and transparency in land acquisition, rehabilitation, resettlement act, my lord, of 2013, my lord. Now, my lord, this is an issue that comes from the Dibang Valley, my lord, where the government has acquired, my lord, for setting up of the multi-purpose Dibang project, my lord. My lord, just to cut short entire matter, my lord, I'll take my lord to page 77, my lord. Page 77 of the writ petition, my lord. That's annexure 5, my lord. My lord will note this final notification was passed on 14th December 2014, my lord. And my concern is, my lord, at page 78. Page 78, my lord will see in that in this column, my lord, 1, 2, 3, the third column. The third column, my lord has got. My lord will see lower Dibang Valley. It says that Dambok Elohi upstream, right of river sources, and the area is 177.663 acre, and the boundaries are in the next, my lord. Now, in order to clear, so far it is fine, my lord. Now, my lord will see page 63, my lord. That's annexure 8. This is from where the dispute starts, my lord. So I'm just taking, my lord, to the specific pages and my contentions, my lord. Page 63, my lord, as see. Here, my lord, the private respondents, my lord, the private respondents submits a list of name to the deputy commissioner, my lord, claiming themselves. Now, claiming themselves to be the affected landowners who is entitled to get the compensations, my lord. So this was in the year 2016, my lord, they have submitted. And subsequently, my lord, my client, who is actually the traditional, the landholders or the possessors of this particular stretch of lands, my lord, which was supposed to be acquired, came to know, and accordingly, my lord, we have filed our first complaint that is at page 100, my lord. Annexure 11, this is our first complaint, my lord. This is our first complaint, my lord. So we have addressed to the deputy commissioner, and we say that may I just be permitted to read, my lord, what is that? This is dated 30th of March 2021. And I said that complaint against illegal inclusion of Adambo, Mayapa, Elohi area under Elapa mini Shango, my lord. Respected sir, the undersigned would most humbly and respectfully like to put forth their genuine indignation and quandary by placing their grievances and calls upon your good office to do the needful to correct the commission and emission which has been described in the detail herein below for your kind perusal and necessary action, please. That's the area known as Adambo Mayapa Atto, located within the fern belt of Elohi so-and-so river, since ages has been illegally encroached and highlighted as Ilapra Elohi and Mini Sango for the purpose of land acquisition regarding the Dibang multipurpose project. Therefore, in this regard, to reclaim our ancestral land, we, the ancestors and the only immediate relatives of the said clan, namely Adambo Mayapa, would like to lodge a complaint against the above mentioned area, that is Ilapra Elohi, Mimi Sango, with your good office and register our rightful, legitimate and traditional ownership over the said area, requesting you to issue an order to challenge the dispute and ownership in a proper civil court, so and so, my lord. So now, my lord, it was not done anything. Therefore, my lord, we were compelled to lodge another complaint, my lord. The second complaint, my lord, will find at page 102, my lord. Annexure 12, my lord. This is our second complaint, my lord. So, my lord, I will not read the entire thing because some substance is the same thing, my lord. Now, my lord, our grievances has already been acknowledged, my lord, and has been admitted also by the respondents, my lord, by the respondent authorities. My lord, page 218 of the affidavit filed by the government, by the deputy commissioner, my lord. It will be little trouble for my lord. I'll just take the admission, or I'll just read, my lord. My lord may kindly note the page. Page 218 of the affidavit in opposition filed by the respondent number 3. In this, my lord, that is the date is of 27th November 2021, my lord. November 2021, my lord, this is important, my lord. And here, Deputy Commissioner Lower Dibang Valley writes a letter to the to the Director of the Land Management, Government of Arunachal Pradesh, subject forwarding of complaint copy, my lord. So we will skip at paragraph and serial number 5 that talks other 1 to 4 talks about other land, which is not the concern issue here. 5, the point number 5, that's what concerned us, my lord. So I'll just read that one. Number 5, it says non-disbursement of land compensation of Ilohi Pani area as the land is under dispute and ownership of the land shall be taken up before competent civil court. So they have acknowledged that there is a dispute going on. So therefore, please do not release the compensation amount. Now, my lord, what Deputy Commissioner ought to have done, 2 complaints were before the authority, my lord. He could have exercised section 64. Section 64, my lord, I'll just take the provisions of section 64. What is section 64 of the LAR Act 2013 says? I'll just read. Reference to authority. Section 64, my lord has got section 64.
Yes.
Yeah, my lord, may I read? Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the authority as the case may be, whether his objection be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the right of rehabilitation and resettlement under chapters 5 and 6, or the apportionment of the compensation among the persons interested, provided that the collector shall, within a period of 30 days from the date of receipt of application, make a reference to the appropriate authority. Further, provided further that where the collector fails to make such reference within the period, so the applicant may apply to the authority as the case may be, requesting it to direct the collector to make a reference to it within a period of 30 days, my lord. Now, what the collector did, my lord, instead of exercising these statutory provisions, directed me, says that you please go to the civil court, my lord. Go to the civil court and get your case adjudicated, not to the authority, my lord, to the civil court. So, my lord, rightly or wrongly, my lord, rightly or wrongly, without blaming legal advisors, whoever must be advising, my lord, they went to the civil court. Finally, the civil court comes with an order, my lord. I'll take my lord to the order of the civil court.
Page number?
Page number 106, that's the order of the civil court, my lord. Annexure 14, my lord. And at the operating part of that is page 111, my lord. Well, I'll just read that part. Further, I have also perused the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation, resettlement Act of 2013 as well. On such perusal, section 63 of the said act expressly creates a bar on civil court jurisdiction. As such, section 63 of the said act is hereby reproduced for reference. So that's the provision of bar of the civil court, my lord. Hence, in the light of the foregoing facts and circumstances, and without going into other aspect of the instant title suit, at this stage, I am of the considered view that this court is barred to try the present suit under section 63 of the Right to So and So Act. Accordingly, the instant is dismissed under order 14, Rule 2, and of the CPC. So, but now, my lord, how do the situations that I face, my lord? Deputy Commissioner, 2 complaints were there, did not entertain, in fact, relegated to a court which doesn't have a jurisdiction. Now, I cannot go back to the Deputy Commissioner. So, I exercise the proviso of section 64, which says that if the Deputy Commissioner fails to refer, I may exercise the power to go directly by filing an application. I did that, my lord. I did that. And my lord, and I filed that one. And by this impugned order at page 116, my lord, at 116, my lord, the authority, my lord, the authority allows me, my lord. In fact, my lord, I don't want to create a controversy here, my lord. With statute, strictly, my lord, asks me to go back to the Deputy Commissioner once again, my lord, where I've already gone, and it's telling that he was supposed to direct, but he washed off his statutory duty, and he asks me to go back again, my lord. So now, my lord, in the meantime, my lord, in the meantime, the entire amount of compensation has been disbursed, my lord, disbursed to the private respondents, my lord. But that is not a big issue because tomorrow, my lord, if the authority decides that they have the compensation has been paid wrongly, my lord, there is a provisions under the act itself how to recover, my lord. That's why I'm not very concerned of whether the compensation has already been disbursed or not. We are not much concerned. But the concern is, my lord, I have been running from pillar to post, my lord. I've been running from pillar to post, my lord. As statutory, I've exercised my statutory rights, my lord. The respondents are not adhering to the statutory, they're not following the statutory obligations cast upon them by the statute, my lord. So that is the reason why, my lord, I have to come before my lord. Here also, my lord, I am not asking a mandamus or a certiorari where quashed everything or the proceedings and pay to me, my lord. There would be a disputed questions of fact. What I am praying, my lord, refer back this matter, my lord, with directions to the authority, because my petitions will be pending there already, my lord, and decides in accordance with law. That is all I am asking in these petitions, my lord. And my lord, now...
So this petition is filed under Article 226 or 227?
My lord, this has been filed under 226, my lord, read with 226, my lord.
7.
Whether this
226,
proviso,
my lord, 226/227, my lord.
okay, whether the second proviso
my lord,
of section 64
Yes,
of
my
the Act of 2013 was pointed out to the learned court.
Yes, of course it was pointed out. That is the reason why I went, my lord, there. Page 116, my lord, will come back once again there. The impugned order, my lord. The paragraph 2 of, my lord, what we have pointed out is learned counsel for the petition has submitted that this case has been filed as a reference under section 64 of the right to, as the deputy commissioner review rejected the representation dated so and so, my lord. This was pointed out, and the petition is required to submit appropriate application before the collector deputy commissioner reviewing for reference under section 64 of the and transparency. Learned counsel prays to withdraw, my lord. Here now it cannot act as an. My lord knows very well, my lord. Needless to say, there cannot be an estoppel on the statutory provisions, my lord. So even if I say, today I'm not create controversy here, even if I say that, okay, I'm withdrawing, but you were supposed to act on the statutory obligations. My saying that, okay, I'm withdrawing, I'm going back again, does not play an estoppel on me, because there cannot be an estoppel on a statutory provisions, my lord. What needs to be done, it was supposed to be done. Now I'm left.
Right, but if you wish to withdraw the petition, then whether court will prevent you from withdrawing the same.
My lord, that is the reason why I'm saying, my lord, this was with due respect and with humbly to respect to the authority, my lord, and district concern. This is an order which was put into the mouth of the council. With due respect, my lord, I'm saying that. But be as it may be, my lord. But when there is a statutory obligations, my lord, which is supposed to be act, my lord, directing me, allowing me to withdraw, because, my lord, what happens now? Where do I go, my lord? Deputy collector has already rejected me twice. Now the authority is rejecting me. So so I cannot be left remediless.
Lordship, yes, I'm for the private respondent, Lordship. Before I start, Lordship.
What is your stand?
Lordship, they are claiming my lane, Lordship.
Pardon?
They are claiming my lane, Lordship, for which I have already been compensated, Lordship. Lordship, the acquisition started way back in 2011, Lordship. The acquisition was taken place as per Land Acquisition Act 1894, Lordship. The entire process was completed, Lordship. Now, in that entire process, Lordship, when the hearing, everything was taking place, Lordship, they have not whispered any word of protest against my lane, Lordship. Entire process was completed. Award was passed in the year 2019, Lordship. Now, after 2.5 years, Lordship, they are approaching before the authority and agitating that the land belongs to us, Lordship. Now, accordingly, the authority has clearly directed them to, since they were disputing our title, Lordship, over the lane, Lordship, after compensation was paid, Lordship. Now, the civil court rightly have rejected their application, Lordship. Now, again, they rush before the reference authority under Section 64, Lordship, without filing a proper application before the Deputy Commissioner, Lordship. Now, that was clearly highlighted by the reference authority, saying that since you have not filed any application before the Deputy Commissioner, you go back and file an application. Then, if they are not referring it,
They have filed to complain before.
no, that was not under Section 64, Lordship. Now, Section 64 has to be very specific, Lordship. Now, in that 2 applications, Lordship, my learned friend has read out, Lordship. There, they have not mentioned about Section 64, Lordship.
No,
They
not
were
yet.
disputing the
Not
title only, Lordship.
Of the section or wrong quoting of section. Oh, whether it would stand in the way of granting any relief.
Yes, Lordship. There, under Section 64, the application has to be very specific and very clear, Lordship, saying that the Deputy Commissioner has to refer it before. Now, the Deputy Commissioner will see this Section 64, whether that matter is fit for referring that matter to the reference authority or not. That has to be seen, Lordship. Now, my learned friend has not read the section completely, Lordship. There are other clauses which has to be pondered upon, Lordship, which has to be looked into. There are limitations, Lordship. They are barred by a limitation, Lordship. The award was, Lordship, may kindly take up, Lordship. Lordship, may kindly take up section page number 626, and answer 65 of my affidavit.
Page number?
626, Lordship. 626.
Yes.
Now, this is the letter of 22nd February 2012. By this letter, Lordship will become clear that, Lordship, the award was approved by the concerned authority, Lordship. Now, this approval of award was well within the knowledge of the petitioners, Lordship. Since their claim was in some other lane, Lordship, they were compensated, Lordship, in that lane where they have been claiming, Lordship. They have already been compensated in those lanes, Lordship, which is part of the notifications.
This award was approved by the government on 22nd of February
2019, Lordship. They have approached the authority. Complaint was filed when, Lordship. Even if presuming that this complaint is appropriate, Lordship, their application was filed when, Lordship. Lordship, may kindly take up their affidavit, Lordship. Page number 100, Lordship.
102.
101 is the
Yes,
type
it
copy.
was
Two complaints they have
for
filed.
2021.
Lordship, 2 complaints, in fact, they have filed. 33/2021, 16/4/2021, Lordship. After a lapse of 2 years of the award, Lordship. Generally, Lordship will see Section 64. If the parties agree against the award,
No,
then they come to the Section 64, Lordship.
whether any limitation is provided.
Lordship, yes, Lordship.
Wait.
Section sub clause 2, Lordship.
30 days.
30 days. Down below, Lordship. Section 64 sub clause 2, A and B, Lordship, may kindly see. The application shall state the grounds on which objections to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under Section 21, or within 6 months from the date of the collector's award, whichever period shall be first. Provided further, the collectors may entertain an application after the expiry of the said period within a period of 1 year. Maximum limitation is 1 year, Lordship. If he is satisfied that there is a sufficient cause for not filing it within the period of specified in the first proviso. Now here in their application, they have to clearly mention why they have come before the authority, concerned. That particular limitations, conditions has to be clearly mentioned, Lordship. And then their application also has to be very clear and specific, saying that the matter has to be referred before the reference authority. Then sections, if the collector is satisfied that he's well within the limitation period, then section 65 is invoked and the matter is referred before the concerned authority. That they have not done it, Lordship. So why the reference authority has clearly observed in the order, Lordship, my learned pen has just read it out. So they have sought liberty to file an application before the authority concerned, Lordship. Page 117 of their affidavit, Lordship, may kindly take up. The petitioner are at liberty to submit appropriate application before the deputy commissioner, come collector, and the same shall be decided in accordance with law. It is needless to say that the learned deputy commissioner shall decide the application. Page number 117.
117. No, this is the order passed by the district judge.
Yes, he is the reference authority, Lordship. They have directly rest before the reference authority without filing appropriate application before the deputy commissioner.
In the complaint filed by them, deputy commissioner has, upon the complaint filed by them, deputy commissioner has passed the order dated 19th of July 2021.
To approach the civil court.
Yes.
Yes, that is not a problem, Lordship. Since they were disputing the title, Lordship.
No.
Again, their Lordship, reference authority cannot decide the title, Lordship. They are very specific and clear. Section 64, on certain conditions only the reference authority can take up the matter, Lordship.
No.
Apportionments.
You have referred to the limitation. Whether this limitation issue was taken up by the deputy commissioner.
They have
dated 19th of July 2021.
Lordship, they have never agitated before the reference, before the authority concerned, Lordship. That applications, they have not mentioned anything in their application. In their application, Lordship may kindly see what they are agitating. They are only disputing the title, Lordship. Now, title, Lordship, reference authority cannot decide, Lordship. Only civil court only can decide, Lordship. So why the deputy commissioner has rightly directed them to approach before the civil court. Accordingly, they have approached the civil court.
How the civil court will decide when there is a bar? You see the order passed by the civil judge? At page number 111, it is clearly stated that under section 63 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The civil court is barred to try their presence of.
Correct, Lordship. They cannot, when the entire process in the entire, Lordship, this is the part of the observation. Rest of the observation, Lordship, the petitioner has not, starting to till then, how he has come to the conclusion that is there in the previous paragraphs, Lordship. How the civil court has come to that conclusion, Lordship. Lordship, as I have been contending, Lordship, since 2001 till approval of the 2019, Lordship, they have not whispered anything in regards to disputing the title of my lane, Lordship.
No, maybe.
Lordship,
The order passed by the deputy commissioner is silent on that point.
Lordship, so a deputy commissioner, since deputy commissioner will obviously act upon the application that will come to his office, Lordship. Accordingly, he has acted upon that application, Lordship. If this application was for application under Section 64, Lordship, the Deputy Commissioner would definitely would have acted as per Section 64, Lordship.
Yes, Mr. Nabam.
Okay. My lord, it says, my lord, the petitioner, they are shifting their burden to the district administration, or just like a, or I would say, my lord, the kettle is calling the pot black, my lord. Now, in this case, whatever the prayer made by the petitioners, my lord, that matter should be returned back to the deputy commissioner, my lord, so that he can rethink over, my lord, about his decision, my lord. Now, I find, my lord, if you lordship kindly peruse the prayer made by the petitioner, my lord, there are only two prayers, my lord. The land acquisition process should be set aside and quashed, and mandamus may be issued to the deputy commissioner to recover the amount. These are the two specific prayer made by the petitioner, my lord. Now, when you see, my lord, the notifications, my lord, under section 4, 6, whatsoever, maybe, my lord, either all Act 84 or my lord, 2013, my lord, all the stakeholders, they are given notice, my lord, giving 30 days minimum to raise the claims and objection, my lord. And when we see, my lord, preliminary notification, the final notification, my lord, it was issued long time back, my lord. Pre is somewhere in 2013, and final is somewhere in 2014, my lord. Now, when you count, my lord, the period, my lord, from the date of final notification, 2014, and when the petitioner, my lord, wake up from the deep slumber, my lord, somewhere in 2014 or 2021, my lord. So when you count from the final notification till, my lord, the first representation they have submitted, 2021, there is a, my lord, hiatus of 7 years, my lord. That 7 years gaps are there, my lord. Now, as your lordship is aware, my lord, now land acquisition are made under, my lord, eminent dominant, my lord, as a requirement, my lord. Then when we make a land acquisition, my lord, say for example, awards. Now, if the beneficiaries, my lord, they are not satisfied with award or the measurement, my lord, they can go for reference under 64, my lord. There is no doubt about that. Now, before that, my lord, what one has to be satisfied, has to, my lord, demonstrate himself before the district, my lord, is the ownership, my lord, land ownership. Now, when this final notification is issued, asking for the claims and objection, my lord, the petitioner, my lord, they never raise any objection, my lord. So meaning thereby, my lord, they have waived their rights, my lord. Or perhaps, my lord, that area does not falls under, my lord, the petitioner's land, my lord. Maybe because of that, my lord, they did not raise any objection, my lord. As my brother was saying, my lord, whatever, my lord, land compensation, that acquisition process that falls under the petition, that has been only compensated to them, my lord. Now, my lord, 2021, perhaps, my lord, then they, my lord, submitted a representation to the Deputy Commission, my lord, disputing the title, my lord. Now, when your lordship may kindly note, my lord, the things was already settled, my lord, prior to 2021, my lord. They raised the claims and objection only 2021, my lord, not pertaining to assessment, not pertaining to, my lord, quantum amount, but the ownership of the land, my lord, the title over the land, my lord. Now, who can decide, my lord, title, my lord? Obviously, my lord, under 64, my lord, it cannot be, my lord. The reference code there, my lord, they are restrained to, my lord, only execute a certain, only the quantum, my lord, amount, or the acquisition, my lord, the measurement, all these things, my lord. So for title is concerned, my lord, civil court is the competent authority, my lord. Now your lordship pose a question, my lord. The order passed the civil court, my lord. My lord, I can understand, my lord. This 1111, my lord. The last part, my lord, referring to 64, my lord. My 63, my lord. I may not agree to, my lord, the civil court's order. Having said that, my lord, this was never challenged before any authority, my lord. They ought to have challenged. My lord, when they file a suit before any competent authority, it is the duty, one of the, my lord, that competent authority, as per the provision of law, he should decide the title, my lord. The deputy commissioner or the reference court cannot decide the title, my lord. Now, the section 63 has been quoted by the learned, my lord, JMFC, my lord. This may not be appropriate, but this attended finally because no one challenged, my lord. The petitioner never challenged, my this is wrong, whether he could appeal against this order, my lord. That is not before lordship, my lord. The prayer are very specific, my lord. Acquisition process should be set aside and passed. Mandamus should be issued to the deputy commissioner to recover the amount. These are the two specific prayer made by. Then, my lord, what the other side make a prayer, my lord. My lord, I may be wrong, my lord. My lord, saying, my lord, statutory obligation, my lord. Yes, my lord, we do admit to that, my lord. Every, my lord, competent authority, my lord, they are duty bound to do that. But that's also a text to tango, my lord. Why I'm saying, my lord, your lordship cannot pass any order until and we file any appropriate application, my lord. The statutory obligation will be activated once somebody approach on right time, my lord. Now, my lord, from the first notification, there's a gap of 7 years, my lord. Nothing, my lord. No one approached, my lord. Everybody is happy, my lord. Now, my lord, 2021 only, my lord. They try to, my lord, dispute the title, my lord. They never challenge the acquisition, my lord. You lordship kindly see the representation submitted by the petitioner, my lord, today. They have not challenged the acquisition process, my lord. They have only challenged the title, my lord. Now, last time, my lord, if your lordship records, my lord, that Mihi Laling case, that paragraph 26, my lord. The paragraph 26 clearly said by the Supreme Court, my lord, if once the process is completed, my lord, complete means, my lord, compensation amount is paid, my lord, titles are, my lord, exchanged, my lord. If the process is completed, it cannot be reopened, my lord. Number one. Number two, my lord, in that case also said, my lord, there was a directive from the division bench of the Guwahati High Court, my lord, to give all solution benefit to all the, my lord, beneficiaries under even 1947, the Jom Land Act, my lord. That was quashed, my lord. The third part, my lord, your lordship was, my lord, last time questioners fallen from lordship to all these standing councils, my lord. The last part which says, my lord, pending cases, my lord. And pending cases before any appropriate authority, my lord. That was the last observation made in Mihilang. Appropriate authority, then in this case, my lord, even the land acquisition
Not
my lord.
only appropriate
Now,
authority, but also tribunal and court.
I said appropriate, that can be reference to tribunal before the state government, before the any high court also, my lord. My lord. Now, my lord, the first paragraph is very clear. If the process is completed, it cannot be reopened, my lord. And here is the case, my lord. It was already completed long time back. My lord, the compensation amount has been given to all the beneficiaries, my lord. Now, process is completed. Now, after lapse of 2 years, my lord, they are approaching your lordship to quash that proceedings, my lord. That land acquisition proceedings, my lord, which they never submitted any representation, my lord.
No. Now, today, the counsel for the petitioner has submits that the impugned order is annexed 16.
My lord. Molding of the relief. Is what I'm saying.
Now, all right, my lord, whatever prayer is made by the landed council for the petitioner, my lord.
But
the lordship may kindly see the prayer, my lord. Lordship may kindly see the prayer portion, my lord.
No, that's all right. But this order is not impugned in this writ petition. No?
Which order your lordship is?
Annexure 16.
And I shall stick to.
So you are not challenging this order?
Annexure 16, the civil courts order, my lord?
No.
No, my lord, this is not,
Procedure.
they have not challenged in this petition, my lord.
Hmm.
There is no any whisper about that, my lord. If you look, that's why I was insisting you lordship may kindly see, my lord, the prayer person, my lord.
That by setting aside this order, the matter may be referred to him. Referred to this court.
But that is not the prayer, my lord.
This court.
I'm sorry, ma, that is not the prayer. That's why I was insisting you lordship may kindly see the prayer person, my lord.
Yes, I have seen it.
So that is not the prayer, my lord. That is not the prayer. The prayer is very specific, my lord. Acquisition process to be set aside and cost. Mandamus should be issued to recover the amount. These are the two specific prayer made by them. So that's why, my lord, there is nothing informative whatever my deputy commissioner, my lord, referring the matter to the my lord, civil court so that they could, my lord, sort out the title for claiming, my lord, the ownership, my lord.
Okay.
So nothing wrong is there, my lord.
May kindly note one point also. Okay?
Yes.
This order of reference authority at page 116. This was passed on 31/8/2022, lordship. And when they have approached this authority, lordship, or this court, lordship, after 1 year.
No, that is not impugned in this appeal. No, in this petition, though he has submitted.
Verbally, my lord.
My lord,
But I'm sorry, my lord, in verbal submission, you lordship cannot issue any mandamus, my lord.
Mandamus.
my lord, I'm standing here as an officer of the court, and at the bar, my lord, my prayer, accepting my prayer is going to create more problem. That is the reason why, because the entire process, it's not only me. If I'm challenging the notification, it's going to affect the entire people who have received. That's the reason why today I'm seeking for molding, coming a very specific and a very simple solutions, my lord. And also, my lord, they have admitted, when was the award passed? Okay, up to when the award was passed, there's not a problem for me. That's what I've been saying. But the moment after the award, when they've submitted the final list of the affected, that is where, my lord, when I come to know, that is where my course of action has started, my lord. That is where 2021, I started filing representation. And in July 2021, the respondents, deputy commissioner themselves has acknowledged by writing to the higher authorities, say, please do not disburse the amount. There's a dispute. So therefore, my lord, they cannot shunt me away by saying that now, by going to the technicalities and saying that, no, the award was passed that day, why didn't you come? Because it is their own action that given rise to a cause of action for me, my lord. So that is just all, my lord.
Lordship, may kindly take up page 408, lordship. I'll just point out something, lordship. Very interesting, lordship. 408, lordship. This is a NOC, lordship. 408 of my affidavit in opposition. This is a NOC given by the petitioner number 1. Very interesting, lordship. Here, this person, petitioner number 1, who is said to be the chairman of Sindika Welfare Society, lordship. Now, he himself has given the NOC, lordship, saying that that land which they are disputing now, that belongs to us. Now, how can they blow hot and cold, lordship? One point of time, they say that that land belongs to us by giving this NOC. And now, 2021, after the compensation was already, acquisition process entire was completed. Now, 2021, after by every time they are barred by the provisions under 2013 Act, they suddenly come and they start agitating. How can they, lordship? How can they blow hot and cold, lordship? This is very clear, 408, lordship. How can they agitate, lordship? That entire thing was observed by the civil court, lordship. Lordship, if we start reading from the first paragraph of the order, Lordship. Every detail of the argument that was put across before the civil court was highlighted, or this very point which I'm highlighting right now, Lordship, that was taken into cognizance by the civil court, Lordship. And his application was accordingly dismissed, Lordship. They are stopped from agitating now, Lordship. And more importantly, Lordship, in the same area, Lordship, same lane acquisition process, Lordship. Now they say that only 2021 they came to know about this the particular lane which they are disputing, Lordship. No, Lordship. They have I have so many documents to show in my affidavit in opposition, Lordship. Entire hearing that has taken place, Lordship. They were present, Lordship. They never agitated, Lordship. I have annexed the attendance also, attendance sheets also, everything, Lordship. They were part of the entire acquisition process since day one, Lordship. The applications that they were filing since day one, Lordship, for some other area, Lordship. Not in our area, Lordship. Now this NOC, Lordship, speaks volume, Lordship, how they are misleading the court, Lordship. And in fact, in another area where they were claiming, Lordship, already they have taken the compensation amount, Lordship. Now, how can they come back again and revert back again and they try to challenge the award, saying that we were not aware about that award, Lordship? How can they say? They have received the compensation amount, Lordship. Petitioner number 1 and 2, Lordship. They have already received the amount, Lordship. I have annexed that also, Lordship. Lordship may kindly take up section 363, Lordship. This is the attendance sheet, Lordship. This is the
Page 63.
363. This is the hearing that was taken place on 18 April 2016 in regards to the same lane which they are disputing, Lordship. Lordship will find this is the attendance sheet. They were very much present on the day, Lordship. They never agitated, Lordship. They have put their signature. They have given the NOC saying that yes, that this particular lane belongs to us. Page 363, Lordship. This is hearing on section 9 of the Land Acquisition Act 1894, Lordship. The hearing that has taken page 365, Lordship. Serial number 36. This is the petitioner number 1.
Serial number?
36, Lordship.
No, in 363.
Lordship, this is the attendance sheets, Lordship,
Yes.
starting from serial number 1. Lordship, the petitioner number 1, Lordship will find him at serial number 36, page 365. He was very much present, Lordship. Tengari Lingi, Lordship, public leader. He has put his signature, Lordship. And 366, Lordship, petitioner number 2. Serial number 58, Dingu Lingi, Lordship. See, he is the petitioner number 2,
Page number 3.
66.
Petition number 2 is at serial number?
Serial number 58, Dingu Lingi. He is the petitioner number 2, Lordship. He has put his signature, date, everything, Lordship. Same day he was present, Lordship. Attendance of meeting held in connection with hearing conducted under section 9 of Land Acquisition Act 1894 for acquisition of land for DMP so and so on dated so and so for illegally submergence, illegally downstream under so and so. This is the lane they are disputing, Lordship. They were present, very much present, Lordship. They never hesitated, Lordship, at that point of time.
Okay. Yes, anything to reply?
My lord, yes, my lord. Now, my lord, first of all, I'd like to reply to the NOC, my lord. NOC, my lord, in my rejoinder at paragraph number 5 and number 6 on affidavit, my lord, that has been replied. The question that has been raised for regard to the NOC, my lord. That is one thing, my lord. Now, the second part is, my lord, attendance sheet, my lord, what we have decided there, what we have not decided, those are all subject matter of dispute. Rightly said, my lord, if they have not submitted subsequently the list of the affected, which is a bogus list, my lord, we have no problem. So therefore, my lord, now my friend has brought to the notice of my lord all this proceeding, my lord. This gives a more a reason to go and decide by the authority in what manner it was done. My lord, these are the disputed questions of fact which my lord will not decide. So therefore, my lord, this has got more reason. I must be grateful to my friend, is helping me more. So saying that, yes, this is a perfect case to go to the authority and decide. So therefore, my lord, I humbly request, my lord, I humbly pray, my lord, I'm seeking for the molding the relief. Why? Because, my lord, I'm not sticking to the original prayer, because that is going to create more chaos, my lord. And I stand by what the learned additional advocate general said, that once process has been completed, you cannot challenge. That is the reason why I'm giving up that prayer, but my grievance still stands. My grievance still stands, and that can be resolved. That can be resolved rightly or wrongly, this way or that way, by the authority. I only deserve, my lord, that much of my legal rights to be protected. That is all I have to submit, my lord. Obliged, my lord.
Yes, anything in respect of the molding relief?
My lord, only I can say that your lordship may not give any scope, my lord, where they in future they'll take it as a handle to approve for any appropriate authority. That only the response to the molding of the prayer, my lord. My lord, in our affidavit, my lord, paragraph 5, 6, and 7 of the government affidavit, my lord, filed by the deputy commissioner, my lord, we have clearly said, my lord, everything, my lord. Because I didn't read out, my lord, it's a long paragraph, 5, 6, 7, 8, my lord. While delivering the judgment, your lordship may kindly take note of these paragraphs, my lord.
Respondent number 4 and 5.
Yes, my lord. No, 1 and 3, my lord. Deputy commissioner, my lord. 1 and 3, I think. 1 and 3, my lord. Let me recheck, my lord, before I make any wrong submission. Yes, my lord. 1 and 3, my lord. Yes. 2 also, my lord. Now, my lord, we represent even 2. Even 2 also we represent now, my lord.
Dated 27th of August 2024.
Yes, my lord.
Okay. You are referring to paragraph number?
Paragraph 5, 6, 7, and 8, my lord. Or 5 to 8, my lordship.
5, 6, 7, and 8.
8, my lord. Yes.
Lordship, may kindly make one observation here, Lordship. Initially, they came up with, as my learned senior counsel has already submitted that part, Lordship. Initial, their prayer was on different footing, Lordship. Now, when we filed our affidavit in opposition, now they have molded the prayer, and they knew that this prayer cannot be entertained by this honorable court. Then they tried to mold it, Lordship. Lordship, here, since I have been submitting, Lordship, paragraph page 117, Lordship. There, the reference authority has clearly directed them to approach before the deputy commissioner to submit a application, proper application. That they have not done it, Lordship. And they have, after 1 year, Lordship, they have rushed before this honorable court, Lordship, with this prayer, Lordship. Now, after filing of our affidavit in opposition, after seeing all those stand that we have taken, Lordship, they are molding the prayer. How can that be allowed, Lordship? Now, this order, they have never prayed for modification. They have never challenged this order. Lordship, how can this honorable court, Lordship, interfere in such matters, Lordship? So, my humble prayer, Lordship, humble submission would be to, it's a pit case for dismissal, Lordship.
My lord, I'll just submit this submission, the citations, my lord, regarding the astropel, my lord. Paragraph 10, I've noted up there, paragraph 10, 11, 12, these are the relevant portions, my lord.
Okay.
Excuse me. I've noted on the above, my lord. My lord. Obliged, my lord.
Sir, your name, please?
I'm P. Yobin, my lord.
P. Yobin, learned counsel for the petitioner. Mr. Zini for the respondent number
4 and 5, Lordship.
4 and 5. Mr. Y. No, Mr.
Aris
Aris Nagam, learned additional advocate general for the respondent number 1 to 4.
1 to 3, my lord.
1 to 3.
My lord.
Argument concluded, order reserved.
My lord.
My lord, we are deeply obliged, my lord.
Much obliged, lord.
Item number 6.
Your lordship, it is, I'm the my lord petitioner, my lord. This petition is relating to land possession rights and all
Yes.
of the people, the very people of Namsai, my lord, Lekang, my lord. The respondent number 1, IOC, Indian Oil Corporation, has filed their reply, my lord. But what they have done is, in their reply, they have categorically made this statement that state government, land department is the befitting party to give clarification on this issue, my lord. That's why, in my opinion, my lord, Secretary Land Management, Governor of Arunachal Pradesh, his stand will be required, my lord. Please come to the affidavit in opposition filed by this IOC, my lord. They have mentioned that this issue should be decided by the state government. Page number, my lord. Page number 197, paragraph 3, my lord. So let's go to, my lord, last line, my lord. This honorable court and is not being pressed by the opponent one way or other at this stage, as the same would be more competently answered, replied by the state of Arunachal Pradesh, my lord. In our opinion also, IOC is right here, my lord. So this, whether the non-indigenous people of this Lekang, Namsai, of Arunachal Pradesh can have land possession certificate in Arunachal Pradesh or not, that can only be clarified by the Department of Land Management, my lord. But they have not filed their this. Otherwise, my lord, they have given us some this RTI, my lord. In RTI, it is clear that it cannot be a person having stand in Lekang cannot have LPC, my lord. That can be seen in our writ petition, my lord. Page number 153, my lord.
So here, Director of Land Management.
Secretary would be better, my lord.
Secretary.
My lord.
Lordship, here in this case, Lordship, is not LPC, this is LOC. Land occupation certificate has been issued to the respondent. LPC is issued by the government to the private lands. But then LOC is, there is no such as LOC as authentic certificate. So far, I am told, Lordship. And government land is issued to the Lordship as government land allotment. And private lands are given as LPC.
My lord.
This is LOC,
There is no provision of LOC in Arunachal Pradesh, my lord.
And in this regard, Lordship, the government has, the Deputy Commissioner has filed affidavit saying that, Lordship, this LOC was issued by the DLRSO.
Yes, my lord.
And so he have no knowledge about this. It's not written here in the affidavit, Lordship. because affidavit, they have only said that this has been issued by the DLRSO. So I, Lordship, actually called up and asked them,
My lord, please come to page 153.
Page?
Come to
53, page 153, my lord. Otherwise, the private respondent, number 8, doesn't have right if we go through, rely on this, my lord. Page 153. It is this RTI reply, my lord, issued by the this government of Arunachal Pradesh, my lord, Department of this land management. May I read, my lord? Is the DAC number system maintained through Chita Register revenue document previously issued to the non-APST people of Lekang constituency, Circle Mahadevpur, valid as on date? Yes or no? If yes, kindly provide the provision. Government clearly said no, it is not valid. Can land possession certificate LPC and land occupation certificate, land holding certificate, NOC, etc. be issued through DAG number in Lekang Circle? Yes or no? Government clearly says no. Can any legal agreement against land be valid on the basis reference of DAG number Lekang area for lease agreement for petrol pump distributor corporation land agreement, encumbrance loan, wine shop trading license, etc. Yes or no? Government say no. That is our actually moot contention that the private respondent cannot hold and lease such land to private respondent is not an indigenous, non-indigenous person of Arunachal Pradesh, my lord. That is why, my lord. And there is one regulation, Bengal Eastern Frontier Regulation 1873, my lord. It making Arunachal Pradesh a special and protected state, my lord. So going through this, my
Subsequently, that has been modified, perhaps.
My lord.
The government has modified that list. That list you have referred to.
BEFR.
My lord, here I'm appearing for respondent number 7 and 8. Respondent number 7 is the beneficiary, my lord, and who is an APST, Arunachal Pradesh Scheduled Tribe. And respondent number 8 is the person under whose occupation the land is. He is a permanent resident of that area. Basically, what has happened, this writ petitioner, after being unsuccessful in this writ petition itself is misplaced, that I would submit. The issue is the tendering process, my lord. Tendering process, my lord, by the IOCL, my lord. IOCL says, we require this land in this particular area. The applicant must be an APST who has the occupation of land in this area or having some valid lease, my lord. Now this respondent number 7, who is an APST, my lord, Scheduled Tribe, has a lease agreement with the respondent number 8, my lord, who has in his occupation some portion of land which can in the specified area, man. Now the lottery was done, draw was done. After the lottery, my lord, the respondent number 7 was selected, man, on the basis of lottery, man.
Not 8.
Not 8, my lord. 8 is basically the person under whose occupation the land is, my lord, who is the owner of the land, man. Now respondent 7 is the, my lord, person who is the beneficiary, man. Now respondent number 7 has been awarded the tender, my lord, for the retail outlet of the IOCL, the retail outlet, man. Now, after being successful, my lord, unsuccessful, my lord, the writ petitioner comes before this court saying that there is a defect in the title, man. Can this be decided, my lord? This is, and otherwise this tender process, this writ petition is about the tender process. Now the lordship knows, my lord, what is to be seen in a tender process. Only the decision-making process, my lord. Let them show whether there is anything wrong, my lord, anything arbitrary, anything biased, any action done by the authorities, the IOCL, that would confer undue favor or undue bias in favor of the respondent number 7, my lord. Nothing, my lord. Now today they are coming and saying that there is a defect in title, this, that, my lord. Can this be decided in the tender process, my lord? That is the basic case, my lord.
My lord.
Now they say this title, that title. Now he says that the only person, these people who are permanent, basically, otherwise there is no dispute that these people are permanent resident there. Man. There is no dispute as to that. Now, after initially they were given APSC certificates also, man. But later on that was withdrawn, my lord, because now Deori is not a recognized tribe in the state of Arunachal Pradesh. The Deoris are recognized as ST in Assam. Man. But the fact remains, these persons, my lord, after the reorganization of the NEFA, man, that Assam and everything, these persons are permanent residents there, man, since the British time immemorial. They are in occupation of the land, man. Now the DL also what he has done, my lord, that DL also has given a certificate saying that this person, the respondent number 8 is in occupation of this land, my lord, which earlier initially belonged to his grandfather, my lord. So the process of the tender process was fair and it was completed, my lord, without any arbitrary action on the part of ISCM. Now, after they become unsuccessful, my lord, now they are coming today and challenging the title itself, my lord, which is not, my lord, permissible, my lord. And another thing, my lord, now this person says the juries cannot have the occupation of land. And he says, I have a valid LPC. This petitioner is saying that. I have a valid LPC, so I should have been allowed. Now, my lord, if your lordship would just have a glance, my lord, at my affidavit filed by the respondent number 8, my lord, I have also procured documents through the RTI, man. In fact, this is a suppression of facts, my lord. The manner in which the writ petitioner is behaving.
Respondent number 8.
Yes, by 8.
Your Lordship, if this RTI is to be taken, accepted by this honorable court as admissible, then I may be given the first opportunity to hear it. But reliance will be taken on the RTI, my lord. If my friend is saying that this RTI is sufficient for me to go with, rely on, my lord, then I will make my submission.
If your lordship is hearing
LOC clearly, this certificate says, Government of Arunachal Pradesh has, through this RTI clearly said LOC, there is no provision of LOC. That's why we have challenged the LOC in our prayer, my lord. Then I will begin my submission, my lord.
My lordship.
Let him complete.
No, my lord. Then if your lordship is hearing, my lord, then let him start, then we will accordingly reply. Otherwise, this can be disposed, my lord.
Yes.
May it please your lordship. My lord, I appear for
Yes.
respondent 1 and 2. Since I am the one of the principal parties, my lord, may I pray this be taken up on another date which I can appear in person, my lord, and argue. Because the fact is that till the land possession certificate or occupancy certificate are not cancelled, we have to act on them. Secondly, this is a draw process. A draw does not create any right in favor of anybody. Therefore, I have my submissions on that aspect also. Let it be fixed on 28th of April. As for a disposal at the admission stage itself, I will argue in person, my lord.
Okay. Yes, Mr. Zama.
My lord, he's right. That's why this honorable court has clearly said in the outcome of that lottery result will be subject to the outcome of the writ petition, my lord. We have no objection regarding this learned friend's request, my lord. But our submission may be recorded, my lord. In our opinion, stand of the government of Arunachal Pradesh is required. That is our humble understanding. And this submission has been.
No, the respondent number 3 is the state of Arunachal Pradesh.
Respondent number 3 is.
Yes.
3 years.
Respondent number 3 is actually, your lordship.
Otherwise, then what I was trying to show was that when he says a jury person cannot have a land, they cannot occupy a land. He purchased a land from a jury only. That is what I was trying to show.
Number 3 is the state of Arunachal Pradesh, my lord. Yes, your lordship is absolutely right, my lord. So he should have filed this affidavit in opposition, my lord.
Now, who had filed the affidavit?
That was Deputy Commissioner, and Deputy Commissioner's affidavit is, he says, he says, this has not been issued by us. LOC is not issued by us, my lord, he says. Now, he is not in the moot point whether land occupation certificate is valid or not. He's not in moot point, my lord. So moot point would be this record from government of Arunachal Pradesh, my lord. It is a very serious issue, my lord.
Yes, Madam, you file an affidavit then on behalf of respondent number 3.
This is in fact otherwise the
Because it is
tender meter
no,
basically.
it is no, not basically tender matter.
You amend your prayer then. What is praying is
my
for?
brother has not gone through the prayer, I think.
I have gone through it. Man.
I have clearly this challenged the LOC based on which my learned friend, this IOC, has this allotted the this draw, allowed him to participate in the draw, my lord, because the basic on which the decision was arrived at by the IOC. I don't blame IOC, my lord. IOC will obviously act on the certificate issued by the competent authority. But question here we are raising is whether that LOC, which was acted upon by the IOC, was valid or not in Arunachal Pradesh, and we have raised the question of validity of that LOC, my lord. Now, if it is said that it should be limited only up to this draw of lot, then we will have to. We have no case then.
Yes, he has no case, my lord.
But our case is.
But
clear
otherwise,
here,
my lord, regarding my issue and issuance of LOC, my lord, that if that is the main issue, my lord, then there is the issue of the maintainability itself. What is his grievance, my lord? How is he aggrieved, my lord? My lord knows the definition of the aggrieved person, my lord. Aggrieved person, my lord, he has to have some grievance, my lord, against the issuance of. This is not a PIL, man. This is a writ petition by the petitioner, my lord, in a tender matter, my lord. If he says the larger issue is the issuance of the land occupation certificate, my lord, this writ petition, my lord, has to go, my lord. He has to file afresh, my lord, and he has to show how his rights are, my lord, curtailed. How is he a aggrieved person, my lord? That he has to show, my lord. And a person, my lord, unless only a third person can only file a writ petition, my lord, only in the form of PIL, my lord. He has to show then how is aggrieved by issuance of LOC to me, my lord. No grievance, nothing, my lord. So basically, that's what I'm saying is that issuance of LOC is connected to a tender process, and tender process, my lord, will see how that was done. That is the basic issue, my lord. Not the title, my lord. My lord, then otherwise, since it has been adjournment has been sought for, my lord, then next step maybe.
Your pair number 1 is the main pair.
Main prayer, my lord, but offshoot is due to this LOC, my lord. LOC has been
While going to test this tender process, should we examine the LOC or LPC?
yes,
Whether
because
it is
my
rightly issued or wrongly issued?
my contention is, my lord, without that LOC, impugn LOC, my lord, he would not have been disqualified here in the tender process, my lord. That is our contention here, my lord. Without the LOC, and that LOC has been wrongly issued to him. So government of Arunachal, IOC has rightly come up with a statement that it is the government of Arunachal Pradesh who would be befitting party to clear on this stand, my lord. If government of Arunachal Pradesh says, no, Deuri people has right to have land within Arunachal Pradesh, that will have implication, my lord. But if government takes that decision, my lord, I will have to accept, my lord. I will have to accept, my lord. I will obviously have no quarrel on that. But that stand has to be coming forth from government, my lord. That is my humble submission, my lord.
Okay, then madam, let the government file one affidavit on this point.
My lord.
Huh? What next that? Heard Mr. Jamu, learned counsel for the petitioner. Mr. D. Sophie, learned counsel for the respondent number
7 and 8.
7 and 8. Mr. Borua for respondent number
1 and 2.
1 and 2. 1 and 2. And madam for respondent number
3, 4, 5.
3, 4, 5. Mr. Jamu, learned counsel for the petitioner, submits that in view of the grievance being raised in this petition, the respondent number 3, one affidavit from the respondent, an affidavit from the respondent number 3, the state of State of Arunachal Pradesh, represented by the Secretary Land Management, Government of Arunachal Pradesh is necessary in this petition. And as such, he pressed for issuing direction to the respondent number 3 to file an affidavit on this point. We are allowed, Ms. Ite, learned additional senior government advocate, shall file an affidavit for respondent number 3 on next date. Mr. Borua, learned counsel for the respondent number 1 and 2 submits that the matter may be adjourned and to be listed on. Borua on
28th of April, 2804.
28th of April. We are allowed, rest shall list the matter on 28th of April.
Of last.
Item number 7.
Well, this application is for appointment of an arbitrator. Since the parties have not been able to arrive at a consensus for the appointment of the arbitrator, there are some work was issued, awarded, my lord, but during the execution of the work, there have been there are some contractual disputes arose. So accordingly, in terms of the agreement, we have initiated the arbitration proceeding, and we have requested the BRO for appointment of the arbitrator. So, but till date, we have not, till the filing at least of this petition, we could not arrive to a consensus of a particular arbitrator. So that's why this petition has been filed for appointment of arbitrator. Now, this was filed in December 3/12/2025, my lord, and subsequently, my lord, that my learned brother, he sought for some time to file an affidavit, but till that it has not been filed, my lord. So otherwise, my lord, since it's only about the appointment of arbitrator, my lord, may I pray, my lord, this may be disposed of with by appointing an arbitrator, my lord.
Who can be appointed?
Appointment, my lord, there is a list, my lord.
Page number?
No. This is a notification by our court, High Court, my lord. This is the latest notification, my lord. But in terms of the earlier notification, we had suggested few names. That is it page 198, my lord. Page 198, my lord.
Mr. Kato, are you interested to file your affidavit
My lord, in fact,
or not necessary?
my lord, in fact, detailed affidavit, my lord, the pair-wise comment have been received, my lord. However, my lord, for appointment of the arbitrators, my lord, even this entire, my lord, is not required, my lord. Otherwise, my lord, it is not going to be decided the merit of the case before in this court, my lord.
Yes.
But the department, my lord, as procedure, have given, my lord, the pair-wise comments, my lord. And that we have already forwarded to the, my lord, the BRO for vetting and all, my lord.
The entire pair-wise, my lord, as rightly said, my lord, this is not required because that can always be decided on merits, my lord. It can be decided only during the arbitration. So today, this petition only for the appointment of the arbitrator, my lord. So, the 198, page number 198, my lord, we had suggested the names, my lord, and page 199 names would be there. This was in terms of the earlier notification, my lord. Page 199, my lord, Justice retired P.G. Agarwal, Justice
quarter key Justice Agarwal, my lord, and one Bani Kanta Das, my lord.
No, whether technical expert is necessary here.
Here, yes, my lord. That's why we have suggested for one technical expert. In fact, a technical expert would be the best person, my lord, because this involves complex technical issues.
Here the name of Sri B.K. Das is suggested.
Yes, ma'am.
Now the question is whether he is in a position to become an arbitrator in this matter or not. That has to be ascertained first.
That BK Das, he is now in this new list also, my lord. Technical expert that Bani.
In the new list.
New list also, my lord. That serial number 37.
37 BK
Yes.
Das. Okay.
Since he is in the list, my lord may appoint him, and if he has some difficulty, my lord, that can always be.
No, is it not necessary to obtain his consent before appointing him?
That part.
As per the procedure, my lord, your lordship will give the directions to him, his lordship, this technical expert. My lord, if he has any difficulty on the, my lord, from taking up the issue, my lord, he will refuse and send.
No, can we ask the registry to contact him and to obtain instruction in this regard?
Yes, my lord, that can be also done.
my lord.
Okay, then we'll take this matter at 2 o'clock.
2 o'clock.
In the meantime, we will ask the registry to contact that person.
My lord. Okay.
Two o'clock.
Item number 8.
ये वाला वो चैम्बर में रख देते चैम्बर ये भी रिकॉर्ड से
My lord, may.
Yes.
My lord, the petitioner, my lord, he owns a vast area of land in different pocket of taxing, my lord, which is, my lord, the border of Tibet, my lord, which is the last part of Arunachal Pradesh, which is bordering Tibet, my lord.
Okay.
And the taxing, this headquarter, my lord, government is contemplating to this acquire land, my lord, for establishment of headquarter. Earlier, my lord, some of the, my lord, infrastructures, those were built, my lord, on temporary basis. And the present CO building, my lord, CO quarter, my lord, it has been built over my land, my lord, in the year 2001, my lord. Before coming to the PEC, my lord, petitioner, my lord, he has donated land for, my lord, establishment of school, my lord. He has already donated, my lord, free of cost, without this receiving any compensation. That apart, my lord, he has also, my lord, he is ready to donate land for, my lord, construction of outdoor mini stadium, my lord. The area is around, my lord, 13,000 square meters. But this particular land, my lord, since, my lord, I have donated most of my land to the administration. So I want to retain this land, my lord, which I have not donated till that, my lord, and which has never been acquired.
You have already allowed them to establish the CO office there.
No, my lord, it was temporary, my lord, on temporary basis, my lord.
No, unless you provide land where the office will be established.
My lord, for that, my lord, there is Nang Welfare Society in our area, my lord. And we are, my lord, giving this free, vast area of land to the administration for establishment of this headquarter, my lord, without any compensation, my lord. Therefore, my lord, since, my lord, the land where this CO office is standing right now, my lord, it has not been acquired. So there was a meeting, my lord, chaired by the CO of taxing, my lord. And in that meeting, my lord, may kindly come to, my lord, my note of the meeting, my lord. At lecture 2, my lord, page number 90.
Yes.
May I read, my lord?
Yes.
A coordination meeting with order number so and so dated 14 February 2025 on above mentioned subject was held under the chairmanship of Sri Taso Duri, Circle Officer at General Ground Taxing on 28 February 2025. The PRI members, Gaon Buras, senior citizens, intellectuals, and land owners of Taxing Circle participated in the said meeting. List of participants and agenda of the meeting is appended at Annexure 1 and Annexure 2, respectively. During the meeting, the participants were informed of the facts and significance of land demarcation cum land notification for various upcoming development activities at Taxing headquarters, in particular by the chairman. Summary of the points discussed in the meeting. Previously, the process of land demarcation of Taxing Circle headquarters were exercised in twice occasion but failed. The demarcation process requires the need to identify actual landowners and advise them to take cognizance of their respective family members and seek consents for donation of land free of cost. However, the landowners wanted to rewarded with significant compensation like allocation of share in profits against future development work in their land and job opportunity in the Group D post. It will be better if every landowner would donate their land for demarcation of the circle headquarters instead of one or two. It should be made clear which land owner will donate their land to which particular government agency department. Some of the landowners of the other places of Taxing Circle were also interested in donating their land free of cost. So, in case of no consensus between the landowners of present Taxing headquarters, the developmental activities may have to be shifted to some other place within Taxing Circle where landowners are willing to donate their lands by free of cost without any hindrance or objections, and which may be notified as the new headquarters. In this context, some places like Tungba, Malo, Onjing, Lingbing were suggested. Some participants state that the matter of land demarcation will be solved if the concerned political leaders like Honorable MLA and ZPM of the region guide the entire process from top to bottom. There were also suggestions for the formation of circle level development committee to supervise the land demarcation process. There was also a concern raised by one of the participants regarding the plan for the stay of general public if at all of their land would be donated to the departments. Additionally, he also asserted that proper execution of land donation through gift deed should be done, wherein it should clearly indicate the land of which family is allotted to which department. Later, the meeting was concluded with vote of thanks speech from Sri Takia Bai PI, senior citizen of Taxing Circle. The understanding after thorough deliberations and discussions observed that willingness of all the landowners and their family members is mandatory. Family-wise coordination meetings shall be undertaken amongst all the landowners. The aforesaid actions should be conducted and supervised under the banner of Now Welfare Society, and the formation of circle level development committee is not required now. The consent of all the affected landowners who are interested to donate their land by will shall be obtained in writing, and donation to be done free of cost through gift deed. Therefore, all the like-minded landowners, interested persons are cordially requested to submit their expression of interest or no objection certificate in writing with full details of land in connection with land demarcation cum land acquisition for establishment of circle headquarters at Taxing Circle. Whether the EIO or NOC, if any, Circle, my lord. He was the chairman, my lord. And from this document, my lord, it is not disputed that the land where presently Taxing headquarters is established, my lord, it has not been acquired nor donated, my lord. So therefore, this Taxing is such a sensitive area, my lord. The petitioner himself, my lord, he is one of the, my lord, senior citizen of the society. He also wants that, my lord, development project should not stop, my lord. So therefore, the petitioner, my lord, he is now presently holding the chairman of Now Welfare Society. And Now Welfare Society, my lord, they have a vast area of land, community land. This now welfare society, my lord, they are ready to donate land, my lord, which is very much adjacent to the present headquarter, my
If you were not interested to offer the land to establish the circle office, then let them shift it to another place. It will affect the development.
Yes, yeah, only my case here is, my lord. Only my case here is, I have, my lord, of course, donated vast area of land for establishment of school, for my lord, construction of this mini outdoor stadium. This is the last land, my lord, I have inherited from my father. So, my lord, only the thing is that, my lord, it is apparently clear, my lord, this is the first minute. And second minute, my lord, we find, my lord, it was, my lord, it is the minute of 5/5/2025. My lord, may kindly come to annexure 5, my lord.
No, the land in question is your land or it is community land?
It's my land, my lord, private land, my lord. It is my private land, my lord. So, my lord, apparently, my lord, what, my lord, I have impugned in this writ petition is that, my lord, despite the fact that the land has not been donated or, my lord, acquired, the administration, my lord, they are trying to dismantle the existing temporary CO office. And in that place, my lord, they are going to create this new permanent RCC building. So I am, my lord, agree by it, my lord. If, my lord, they are interested, there is process, my lord. My lord is very much aware. Government land, my lord, which are the government land, my lord? Either the land, my lord, that has to be acquired or it has to be donated voluntarily by the individual, my lord. Since, my lord, from the minute itself, it is very much clear, my lord. The land where the CO office is now being proposed to be, my lord, permanently constructed, my lord. It belongs to me, my lord. It is yet to be acquired. If at all government need, my lord, they may go for acquisition, my lord. But before acquisition is done, since I have not donated, my lord, so therefore, my lord, this land, my lord, before it is acquired, my lord, it is my private property, my lord. So my humble prayer in this writ petition is that, my lord, until and unless, my lord, this land is, my lord, acquired with due process or it is donated, my lord, they may not, my lord, disturb my peaceful possession, my lord. That is my prayer in this writ petition, my lord. And the document, my lord.
Your peaceful possession means already office is there.
My lord,
how it is in your possession now?
No, my lord, since, my lord, it is not fit for, my lord, this dwelling, my lord. So therefore, they are
is the office is not
not functioning from there now, my lord, because it is not functioning from this building, my lord. It is not fit for, my lord, this. It is not fit for, my lord, this to dwell on that building now, my lord. That is temporary, my lord, this timber house, my lord, that was built in the year way back in 2001. So they are not even functioning from this, my lord, house. Now, my lord, my lord, I have last week I have filed additional affidavit, my lord. My lord, you will see, my lord, the land which I have donated to the government so far, my lord.
No, not necessary to show all these documents.
And then, my lord, it's, my lord, if my lord is convinced that the land is yet to be acquired or it has not been donated, then, my lord, it's okay, my lord. What, my lord, to substantiate my argument, my lord, I have filed additional affidavit where, my lord, I have sought for RTI information. And in reply, my lord, the PIO, my lord, he has clearly stated that the land has not been, my lord, acquired, not donated, my lord. There is no record as such. That, my lord, additional affidavit, my lord, I have filed, my lord. Where, my lord, I have annexed the RTI reply of the PIO, my lord.
No, here the respondents have taken a stand that the land where the construction of the office building is to take place, there is no such documentary evidence of ownership from the side of the petitioner.
They are, my lord, they are making just a base claim that, my lord, it was donated, my lord. Therefore, my lord,
Where is your reply?
my reply is, my lord, my additional affidavit, my lord.
Para number?
Para number, my lord. My lord, para, it starts from para 2, my lord. This is, in fact, my lord, I am relying on the information furnished to by the PIO, my lord. I have, of course, another additional affidavit, my lord. I have reply their contention in my that additional affidavit. Firstly, my lord, may kindly take up my additional affidavit that the page starts from 27, my lord.
Dated?
Additional affidavit, my lord. My lord, 9 to 20.
Okay.
9 to that, my lord, para it starts from para 4, my lord. Earlier, my lord, I was this issued NOC, this certificate by the GB, my lord, and that has subsequently been withdrawn, my lord, on the pressure of the, my lord, the political pressure, my lord. Para 4, it is, my lord, that with regard to the statement made in para 4, 5, and 8 and 11 of the affidavit in opposition, the petitioner respectfully denies the statement made therein and begs to state that during the year 2001, for the purpose of establishment of circle office at Taxing, the state respondent has approached the petitioner to lend some portion of his private land solely on temporary basis, and on agreement for the same, a wooden type building for circle office Taxing was constructed, my lord. It is, however, pertinent to mention that the said portion of land whereupon the circle office was constructed has neither been acquired by the government nor was donated to the government by the petitioner. It is clearly certified and confirmed by the head Gambura Taxing Ojuju by his certificate that the land belongs to the petitioner and the petitioner is the rightful and absolute owner of the said land. That the head Gambura certification further affirms that there is no dispute regarding the ownership of the said land and the land has always been recognized as belonging to the
No,
petitioner.
that's all right, but do you have any other document to show that it belongs to you?
My lord, there is a certificate issued by the GB, my lord. Otherwise, my lord, I do not have
Any other document?
any other document, my lord.
The certificate issued by the GB
that has not been acquired till date, my lord.
No, that's all right. When the
My lord, I have even this wrote a complaint before the deputy commissioner, my lord. They are not saying that land does not belong to me, my lord. My lord, may kindly see my writ petition. Take up my
they
writ
have
petition
taken
again,
a
my
stand in their affidavit.
my lord.
They have taken a stand in their affidavit that you are not the owner of that plot of land.
My lord, they cannot say that, my lord.
How?
They cannot say that. Then, my lord, in that case, my lord, they will have to say, my lord, if the land does not belong to me, then they should say that no, it does not belong to you, rather it belongs to such and such person, my lord. They are not saying that, my lord. Even despite my complaint, my lord, that complaint, my lord, I have submitted on 28 April 2025, my lord. My lord, may kindly see at page number 24 in my writ petition, my lord.
It's number 24.
Yes, my lord. May I read, my lord? Complaint against proposed construction of a new CO office building at Taxing Circle headquarters regarding. With reference to the above cited subject, I came to know from the reliable source that the circle officer Taxing have issued orders so and so, that is to demolish the old CO office building to construct new permanent building at Taxing headquarters, which is to be taken up by the Public Works Department, Nature Division, Upper Civil Facilities. In this regard, I have no objection in dismantling the old building, but I am objecting the construction of new office building because the particular land is ancestral inherited land which is solely possessed by me to till date. As even today or earlier time, I also have not permitted anyone to use my land to construct a CO office building in the particular plot of my land. Therefore, I am, as a landowner, I fervently request you to halt the construction of new CO office building in the particular land. This is for your favor of so and so. So, my lord, this complaint, my lord, it was submitted on 28th April 2025, my lord. It is now almost going to be 1 year, my lord. We are in March 2026, whereas this complaint was filed in the April of 2025, my lord. With this regard, my lord, I have categorically, my lord, made amendment in my writ petition, but they have said nothing with regard to my complaint, my lord.
Yes, madam.
Lordship, here, what we have stated in our affidavit is that, Lordship, this CO office in Taxing area was established in 1959. And then when the officers outlived, they are trying to build a concrete one now. And now, after 65 years, the petitioner has come up saying that this land belongs to me, Lordship. And then we have said that this was voluntarily donated by the people at that point of time. Maybe it was his father or grandfather, that has not been stated, but by the people of that area, Lordship. And in case it is donation in one of the Lordship earlier writ petition, Lordship, it has already been said that once donated, Lordship, the his and kin, they cannot, Lordship, take back the land donated already by their fathers, Lordship, and forefathers, Lordship. That I have, Lordship. Before that, Lordship, and then, Lordship, in our additional affidavit, one of his cousin has said that that land doesn't belong to him alone, Lordship. It is shared by all of them, Lordship. In my
Your additional affidavit, page number?
Annexer 1, Lordship.
Page
Page
number?
52, Lordship.
52.
52. Lordship, here at Perapur, Lordship, that's are claimed by Sri Tindu Chadar. He is the petitioner, Lordship, as sole landowner over this existing CO office building and other government existing building and nearby area is totally false and fabricated, which may invite legal battle, and it will be disruption for the peaceful coexistence of the family and future development activities. Sir, I, being the law-abiding citizen, believed in the virtue of truth and justice for all, but regret to say that Sri Tindu Chadar's unilateral claim over our common ancestral land, which is already donated to government for establishment of circle office, building, and other staff quarters, which is government properties, now is illegal and setting a detrimental example for the society without taking the popular decision of entire stakeholders of Darcy family of Chadar clan, Annexer A. There's our sole motive behind the halting of CO Circle Office building by Tindu Chadar is to capture the existing CO office area, whereas this site has been surrounded by the CO office and other government staff quarters, and Sri Tindu Chadar had no any personal farmland or his private residential house at nearby CO office building, whereas his present residing SPT building just opposite to existing CO office building is also a CDPO building under Department of District Food and Civil Supply. So his claim over this area is entirely unfounded and illegal. And I, being the one of the stakeholder and intellectual members of Darcy family, nullified his illegal claim, and if amicable decision is not delivered from your good office, then I have to knocking at the door of honorable court so that justice be done to government and our grandfather led missing Chadar, so and so, Lordship. This is the Lordship statement by this. This Abi Chadar is the cousin of this petitioner. As per his Lordship claim, missing Chadar is their grandfather who have donated this land to the government. And as your Lordship have already observed, the GB has already withdrawn his NOC certificate. And Lordship, I have this for
When the present circle office was established there,
Lordship, we have said in our affidavit that it was established in the year 1959. Lordship.
59, where you have stated in which paragraph
Lordship,
of your affidavit?
yes, Lordship. In Parapor, Lordship. Parapor, Lordship.
Okay.
Lordship, no, Lordship, para 5, I'm sorry, para 5. I'm sorry. Lordship, on donation land cannot be taken back, Lordship. I have this one. Paragraph
Decision.
26. Yes, Lordship.
Paragraph number?
Para 26, Lordship.
Paragraph number?
26, Lordship.
26.
Here, the Lordship. The petitioners have failed to establish their ownership and title over any specific area of land except bold assertion that their lands have been occupied by the government by force and no acquisition proceedings has been followed before taking over the land. As noted above, since the area of so and so have been duly donated by the people of area, question of acquisition would not arise. One could have understood if the private land of the petitioners are taken without due process of law. In the considered view of this court, in the state like Arunachal Pradesh, when the lands were donated to the government for establishment of headquarters and other government institutions and offices, no one should be allowed to claim any right over the donated land by way of vague claims without there being any basis, as it will create a chaos in the state at the maximum of the land where headquarters, towns, and other government establishments have been established are all on the basis of the donation of land by the people of the area under peculiar situation at the relevant point of time as the state was under nascent stage. Lordship, here also, Lordship, town was donated, that particular area was donated, and then this petitioner, Lordship, Geku Township, Lordship, petitioner claimed that this was not acquisition and this was so not donated also. So accordingly, this was held by the lordship.
Okay. Okay, we'll pass the order.
My lord,
Reply.
Anything?
yes, my lord. My lord, in fact, my lord, as per my lord, Arunachal Pradesh Land Settlement Record Act also, my lord. That is, what is government land, my lord? The definition is given in section 2, clause H, my lord. What are the government land, my lord? My lord may kindly see this section, my lord.
Section.
Arunachal Pradesh Land Settlement and Record Act 2000, section 2, H, my lord. It says, my lord, government land means land acquired by the government under Land Acquisition Act or through donation of the public for establishment of administrative headquarters, government institution and facilities under various wings of the government or such land as defined under section 9. So therefore, my submission is that, my lord, as my lord has seen the document, the minute, my lord, which was in fact chaired by the CEO of that particular area, where my lord, they are proposing for this seeking land donation from the people of taxing area, my lord. That itself, my lord, it is clear indication that the land was neither acquired nor donated, my lord. And more so, my lord, that apart, my lord, I have filed this additional affidavit where, my lord, I have annexed the RTI reply, my lord, document, where the PIO of that department says, my lord, the land was neither acquired nor donated. There is no such as record in the office record, my lord. So therefore, my friend, he of course has rightly relied the judgment, my lord. That was a case, my lord, where the land was donated, my lord. Here in my case, my lord, even now only, my lord, the government and the administration, they are seeking donation from the people of that area, my lord. So when she could not prove that, my lord, the land was donated, my lord.
The existing circle office was established in the year 1959.
No, my lord. No, my lord. That building, my lord, that is why I'm very categorically stated in my writ petition, my lord. It was, my lord, constructed in the year 2001 only, my lord. They approached me, my lord, for allowing them to construct the temporary building. That is why, my lord, they did not construct the permanent building, my lord. I did not allow them to construct permanent buildings. So why, my lord, they constructed the log house, my lord. So they could not live this beyond 20 years. So why, my lord, they are trying to construct new building, my lord. Support it also, my lord. We are the community. They are ready to, my lord, give them free of land, my lord, for establishment of circle headquarters, my lord, which is just attached to the present area, my lord. So we are ready to give, my lord, vast area of land, my lord. My lord, may kindly see the minute, my lord, which I have annexed, my lord, in my writ petition.
No, I have seen it.
My lord. So therefore, my lord, it is not the case, my lord, they are saying this Tabu Chair, my lord, who has stated that the land has already been donated, my lord. There is no document to prove, my lord, that land was ever donated, my lord. Until and unless, my lord, the land is acquired or donated, my lord, they cannot take up any activities on my land, my lord. That is my case. And that is the admitted fact also, my lord. From the document, my lord, the document which I have annexed in my writ petition is not generated by me, my lord. This is the official document, my lord. The government document, my lord. The two minutes, my lord. And the RTA reply, my lord, which has been furnished to me by the PIO, my lord. It all speaks that, my lord, land was never donated, my lord. So therefore, my lord, since I have donated rest of my vast area of land, my lord, for establishment of school, I am not claiming it back, my lord. Even I have donated land for establishment of this outdoor mini stadium, my lord. I am stick to that, my lord. But at least the land which I have not donated to the government till date, please don't allow the state to snatch it from the petitioner, my lord. That is my humble submission. I have rest of the land, my lord, I have already donated. This is the land, my lord, which I have not donated, and I am residing in the same area, my lord.
Okay, okay.
Much obliged, my lord.
Next.
Appliance.
Item number 9.
Mr. Zamo, you are for the petitioner here.
No, my lord, we are for the respondent number
You are
2,
for
3, and
respond-
4, my lord. 2, 3, and 4, my lord. Petitioner seems
Petitioner
to
is-
be not present, my lord. We were waiting for this in last order. It was directed that extra copies be served on us and served to the government also, but we have not received those, my lord. So we are.
It has not been served upon you.
No, my lord.
Have you seen the petitioner here today?
I have not seen them, my lord.
You have not seen.
My lord.
So we'll take it up at 2 o'clock then. Maybe because of this 1 o'clock now, the petitioner might left the court under the impression that court will
Okay.
sit at 2 o'clock.
Announcement of judgment of Kohima bench. Item number 1.
Late petition dismiss. Next.
Delivery of judgment of principal seat. Item number 1.
Petition allowed. Next item.
May I, Your Lordship? Your Lordship, I beg to mention item number 14 and 15, Your Lordship. In this matter, we have filed our counter affidavit today, Your Lordship. The petitioner is going to file their reply. At least 1 week, maybe. after
Lordship,
1
2
week,
weeks may be granted to file affidavit in reply, Lordship.
Okay. Ms. P. Pango, learned government advocate, with consent from the other side, press for listing the matter after 2 weeks.
2 weeks, Lordship.
Okay, Your
First,
Lordship.
to enable her to file counter affidavit.
Yes, Your Lordship. We have filed, Your Lordship.
They are allowed.
Lordship, there's an interim, Lordship, that may be continued.
Interim order passed earlier shall continue. In
Of
both the
Lord-
matter, interim.
Yes,
order?
Lordship.
Yes, Your Lordship.
Obliged,
Obliged, Your
Lordship.
Lordship.
My Lordship, I beg to mention item number 1. The council, due to some personal difficulties, he could not continue this matter today. Matter may be taken tomorrow, my Lordship.
Tomorrow, day
Yes.
after tomorrow.
Day after tomorrow.
Day after tomorrow.
Okay. Item number 1.
Heard Mr. Arsoner, learned counsel for the petitioner. List the matter day after tomorrow for further consideration.
Your Lordship, I would like to mention.
Mr. Bam, you are appearing for Mr. Soikia. Yes. Mr. Bam, learned counsel appearing for Mr. Soikia, learned standing counsel for APIC.
Your Lordship, I would like to mention this item number 23, my lord. We have to file reply affidavit of opposition, my lord, there. Some time may be granted to us, my lord. Item number 23. I have taken consent from the petitioner, my lord. 2 weeks may be granted, my lord.
Mr. T. Zamo, learned counsel for the respondent, took concern from the other side, so for listing the matter after 2 weeks.
Yes, my lord.
So as to enable him to file reply to the counter.
No. Not reply, my lord. Affidavit in opposition.
Okay, affidavit in opposition.
My lord.
Fair and lot.
My lord, may I mention, my lords?
Yes.
My video is not being on, my lord, but I'm ASG Sviraj. I'm appearing item 12 and 3. But my AOR, his father has expired, so there's difficulty as far as personal difficulty. His father has died recently, so my lords may adjourn this matter to a short date.
Yes.
My lord, if that be the case, I don't know who is the AOR, but here the AOR is Mr. Kamal Saxena. I would normally not object to it. What I'm on, my lord, your lordship, my only grievance is not the main writ petition. I don't have any problem, my lord, in the writ petition. But so you are the AOR?
I'm on behalf of K. Saxena.
He's appearing for behalf of the NSPC. And my lord, only what objection I have is regarding about the contempt. My lord, that if your lordship, my learned friend has an objection, has a problem today, let it be taken up tomorrow. My lord, these are very important because there is a judgment of this court. And if your lordship looks into the order that has been passed by this court, kindly see the last
Yes,
order.
I have remembered it.
Yes, your lordship, see, and only I'll show one latest journal of Supreme Court, 2026, my lord, where it says only for the purpose of circumventing the court's orders, writ petitions are being filed, review has been filed. I'll show that. So let this matter come tomorrow. If my learned friend has some difficulty, I'll stay back and
We
your
will
lordship.
argue on merits, my lord. We'll argue on merits.
No. I only contempt. I'm not arguing on your writ petition. He's only on contempt. We are on contempt, my lord.
The contempt
all,
can be
my
kept.
lord,
Contempt is between the contemptor and the court. He has no locus assistant to
Yes, I will show what
it.
locus I
That's
have
all
got.
that I'm asking. It can't be
I'll
tomorrow.
show. No, I will show it, my lord, before this court, how it is contemptuous, my lord. And there is an observation passed by this court. They are taking a U-turn. They have agreed. It is a consent order by a senior counsel, and I'm agreed. And now they are saying that your lordship will remembering the case, the R&R policy. Now they are saying no, R&R policy is applicable. And at that time, when the matter was disposed of with the consent of the parties, yes, the NSP senior counsel said we are agreeable so far as complaint under Lara Act. And we said, okay, we are going to accept. This is a contention, and today they are turning back and making us full somersault, and they are saying no. Our R&R policy is applicable, denotify all this. What stand they are taking, my lord? Only for the purpose of circumventing the order of this court? And court is taken very seriously, my lord. Kindly see.
No, nobody is circumventing the order of the court. Nobody is circumventing. We'll address on merits. My lord,
kindly take up.
why, when I'm asking for a date on the ground that my AOR...
Your lordship will kindly take up tomorrow. My lord, I'll just humbly request to take this matter tomorrow, my lord. Only the contempt application can be taken up. Let my learned friend take time so far as the writ petition is concerned.
Mr. Das, you say the amount has
both have
already
to be
been...
heard together. When
No. Registry of the court.
Yes.
What I am saying, my lord, if your lordship looks into it, registry of this court. But what I am praying, but today also they have paid because the court.
He is having a double standard.
No, double standard. Let me. This is not the way. Double standard. My lord, what the court said on the day
Yes,
when the
of
matter
course.
was moved.
When you are saying
when
you
the matter
U-turn, I am
was-
also saying double standard. When you are
See,
saying U-turn,
when the
I am also
matter-
saying that. So my lords
My
may give
lord,
me a short date. Today it's not possible for me to argue. my
When
lord.
the matter was taken up by this court, my lord.
Mr. Counsel, one of the senior counsel has been arguing before this court. Please maintain decorum of the court.
My lord, when the matter was taken up by this court, my lord, at the very first in the it was moved. What the court said, the court, your lordship will please see the order that has been
I've
passed.
seen it.
It is a consent order.
Yes.
It is a consent order. So the writ petition, the court was not willing to accept the writ petition. Now the court, they said that, okay, we are going to deposit the entire amount before the registry. This is what the order. But what we have done, we have filed in a contempt, we have filed a miscellaneous application to release this amount. Earlier it was filed. My lord, before when writ petition, before the writ petition was filed, we filed an application before the court in the contempt that the amount by an IA, the amount should be released to us. That's what we have prayed for. For that particular, the matter has come up, my lord. That's the whole case, my lord. Please, I will show before this court, my lord. And they have filed an objection in that IA. That it is, they are saying that writ petition, the contempt is not maintainable. Why? They say that there is no specific direction passed by the court. The requiring authority directed the court by this court, requiring authority has to deposit this amount. What type of, my lord, they are coming up before this court? In a land acquisition matter, there is a clear-cut finding of this court. Okay, what we'll do, the party has agreed to it, consent has been given, they have agreed, and we have accepted. And the court said, okay, they will assess on the basis of Lara Act. Accordingly, 3 months' time was given by this court. They could not fulfill within 3 months' time. They sought for extension before this court. Twice the extension was granted by this court. Their counsel or NSPC also appeared. And ultimately on 1/8/2025, the award was passed. And what they were doing, after 8 months, they have come up, when contempt was filed, they have come up with a writ petition. Now, when the writ petition, they are taking a different stand. They are saying, no, RNR policy is applicable now. And denotified. What type of, they want to circumvent the order of this court? That's what they want to do it. Their whole intention is to circumvent the order of this court. I will show one judgment of the Supreme Court, and if your lordship feels that no, this contempt is not maintainable, I have nothing to say in this case, my lord. I have nothing to say. Your lordship, what I am praying with.
They have deposited the amount before the registry of.
Yes.
Your pair in the IA is to release the.
To release the amount. So let them deposit that. Now today, can they say, my lord, there's no. Writ petition has to be decided, then only it will be, your amount will be. That's what they were trying to now dislodge the complaint, the contempt petition which has been filed. Contempt has been filed earlier, my lord. In March, we have filed, and today they have filed a writ petition before this court, my lord. What is this writ petition they have filed? Only on the ground that they want to circumvent the order of this court. So, your lordship, I will make a humble request to your lordship. Please hear this, at least the contempt. If your lordship kindly hear it, and your lordship feels that no, this will be has to be heard.
No. If the amount is deposited before the registry of this court,
Yes.
what's left to be
No,
then decided in
no.
that matter.
IA
Yes.
in the contempt. What I am saying, IA in the contempt, we are asking for releasing this amount, my lord.
Yes.
That's what we are praying, my lord. This amount should be released to us, to the project affected families. From 2018, my lord, we have been running here and there. Ultimately, a judgment has been passed.
No,
We honored.
directly this court cannot release the amount in your account.
No,
We have
I don't want. To the deputy commissioner. Deputy commissioner.
Release it.
Yes, that's all what we wanted, my lord. A writ petition will be heard. That's what we want, my lord. That's an IA. We don't want directly. How can we, your lordship, I can't take. So your lordship will give direction to that this amount will be deposited in the account of deputy commissioner, and accordingly project affected families will take this money. The landowners.
Okay. What is your stand in the interlocutory application?
My lords are asking me,
Yes.
my lords.
Yes.
My stand is, my lords may kindly stall these proceedings for a few days. I will come out with a detailed reply. In 2-3 days more time, nothing is going to happen. My lords may keep it day after tomorrow. And day after tomorrow, I will argue the matter. Today, I'm not in a position to argue because there are other matters fixed. I was not engaged. But when I'm told that the other side is arguing, I was asked to appear. My AOR is handicapped because his father has died. I only want a 2 days time. That's all.
Okay. Day after tomorrow then.
Very well. Grateful, my lords.
Day after tomorrow.
I'll stay back, my lord.
Okay.
No problem, my lord. I have a matter tomorrow.
Okay.
In fact, the writ petition, we have also filed our affidavit. Writ petition itself is not maintained.
And this is
Because, my lord,
No, that's all right. Then why the notice was issued?
it was not, my lord. How can now I was present, my lord. I was present before this court. If your lordship looks into the
They
order.
have been listed for hearing on the point of maintainability.
Yes. No, we have filed. Writ petition maintainability also we have taken. The government also taken a stand. That's absolutely no problem. On Wednesday also, your lordship can hear both the matters. Maintainability point first. If your lordship feels that it is maintainable, okay, fine. It is not maintainable, it's gone, my lord.
Okay.
Yes.
All right,
Let this.
Mr. Counsel, your good name, please.
SB Raju, my lord.
Mr. S.V. Raju, learned ASG.
SB.
Whether you are appearing for?
My lords, I am
NHPC.
assisting Mr. S.V. Raju, learned Additional Solicitor General of India, my lords. I am Rajat Nair, my lords.
Mr. Rajat Nair, learned counsel, appearing on behalf of Mr. S.V. Raju, learned Additional Solicitor General
Solicitor
of
General.
India. And Miss, your name, please?
M. Bori, Lordship.
M. Bori, learned counsel for the
On behalf of K. Saxena, Lordship, for the petitioner.
learned counsel for the petitioner. Mr. D. Das, learned senior advocate, senior counsel, assisted by Mr.
I das.
I. Das, learned counsel for the respondent number
5 to 13, my
5
lord.
to 13. Mr. Ratan for 1 to 4. 1 to 4. 1 to 4. Heard in part, list the matter on Wednesday for further consideration.
Yes, sir. Both this matter.
Further
Deeply,
consideration of the writ petition as well as contempt
I
petition
am
and also the
deeply
interpretive
obliged.
application.
Deeply obliged, madam.
I am grateful, my lords.
Your Lordship, I'd like to mention item number 10.
Yes.
In this matter, Your Lordship, there has been change in standing counsel for respondent number 2, 3, and 4. So we need some time.
Okay. You are for the
Respondent 2, 3, and 4.
respondent number 2, 3, and 4.
Yes.
I'm for the petitioner.
You are for the petitioner.
Yes.
Your name, please?
Tita.
T. Ita,
Yes.
learned counsel for the petitioner, and Mr.
Tinima.
learned counsel, appearing for respondent number 2, 3, and 4. The learned counsel for the respondent number 2, 3, and 4 submits that the standing counsel for
4 weeks. 2, 3, and 4.
2, 3, and 4 have already been changed, and he needs some time, and he pressed for listing the matter after
3 weeks.
after 3 weeks. Okay, parallel. Yes.
Item number 9.
Your Lordship, petitioners seems to be not present, my lord. In last order, they were directed to serve as this extra copies, my lord. Last order was issued on 25/9/2025, my lord.
Okay.
Extra-
None appears for the petitioner on call. However, Mr. T. Zamu, learned counsel for the respondent number. You are for respondent number?
I am for respondent number 2, 3, 4, my lord.
2, 3, and 4.
4 and 6 also, my lord.
2, 3, 4, and 6.
My lord.
And Madam Wangmo for respondent number?
1 and 5, Miss.
1 and 5. 1 and 5. Present. Mr. Zamu submits that. What is your submission?
On 25/9/2025, this honorable court directed that extra copies be furnished to us.
Submits
government-
that he has not been furnished with the extra copy of the petition despite direction of this court dated 25/9/2025.
My lord.
And accordingly, he pressed for issuing fresh direction to the petitioner to furnish extra requisite copy of the petition to him. However, since the petitioner remained unrepresented today, recessal is the matter on Wednesday or thereafter.
Okay, anytime, my lord, any day.
26 Thursday.
Wednesday.
Wednesday 25.
Okay. In the event of non-representation of the petitioner on that day, appropriate order shall follow.
Okay, your lordship.
Item number 7.
So the registry has obtained consent from that person. He is agreeable to the same. Heard Mr. D. Soki, learned counsel for the petitioner. Mr. Kato, learned counsel, standing counsel for the. No, in what capacity he appears in this matter?
Is the
As
DSGI?
Deputy Solicitor General of India for respondent number 1.
1.
Respondent number 1. In this petition, under Article 226,
Not 220.
No.
Under section 11. Section 11 of the
Section
arbitration.
11. No, this application under Section 11, which in bracket 6 of the Arbitration and Conciliation Act 1996 is preferred by the applicant, namely Roadway Solution Infra, India Infra Limited, H India Limited, for appointment of arbitrator, independent and impartial arbitrator in terms of the contract agreement dated 22/11/2022, which is annexed with the petition as annexure number 2, and the provision of Arbitration and Conciliation Act 1996 to adjudicate upon the dispute among the parties.
Sorry to interrupt,
Mr.
my lord. Sorry to interrupt, my lord. That agreement is annexure 1, not 2. Annexure 1. The lordship has said annexure 2, so it's 1.
Okay,
agreement.
annexure 1. Mr. Soki, learned counsel for the petitioner submits that the petitioner MS Roadway Solution India Infra Limited was awarded a contract of worth rupees 28 crore 70 lakhs 99,650 rupees for supply and erection of corrugated steel pipe tunnel as per detailed specification and project drawing for 60-meter length at kilometer 50.000, 170 m length at kilometer 56.900 on the road Talihar Naso in Upper Subansiri district under 77 RCC stroke 23 BRTF and 140 m length at km 2.000 on road Hapoli, Sarli, Huri under 119 RCC stroke 756 BRTF in Kurumkume district. Project Ansolik. No, Project Orunak
Arunank.
of Arunachal Pradesh. Mr. Soki further submits that the petitioner has duly executed the contract awarded to him by GEM contract number GEMC-511-68772 72-07118 dated 22/11/2022 and by HQCE, which will make it P Oronak, letter number 80290 stroke supply, cut and cover stroke 40 stroke E8 dated 22/11/2022. Mr. Soki further submits that some dispute arose regarding the work, and as such, the petitioner invoked the dispute resolution board, who is decided in favor of the petitioner. However, the respondent herein has raised objection, and the petitioner invoked the clause of arbitration by letter dated 25/9/2025 and sent notice on 28/10/2025 and proposed the name of the arbitrator for mutual appointment of sole arbitrator by letter number 10/11/2025. However, the petitioner and the respondent failed to arrive at a mutual agreement in respect of the appointment of sole arbitrator. And as such, Mr. Soki has contended to appoint an arbitrator from the panel of the arbitrators, which is notified by the registry by notification number 10 dated 24th February 2026. Mr. Kato Learned, Deputy Solicitor General of India appearing for the sole respondent, submits that he has no objection in the event of appointing an arbitrator from the list of the arbitrator panel of the arbitrator that has been notified by the registry of this court. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, Shri Banikanto Das, advocate and former chief engineer and secretary to the Government of Assam PWD Assam, is appointed as sole arbitrator. In terms of above this petition application under section 11(6) of the Arbitration and Conciliation Act 1996 stands disposed of. Any further direction?
Well, that would suffice. Yes,
Suffice.
my lord will make a mention that his consent was taken by the registry. That,
No, that is informal.
okay, my lord.
Informal.
All right.
Item number 11.
May I please, Your Lordship?
Mm.
My lord, when this application was filed, my lord, at that relevant point of time, there was no tribunal set up, election tribunal set up, my lord. I've been informed now that there is a district and session judge, UPR, has been designated as an election tribunal, my lord, to take up all the election matters arising out of panchayat. My lord,
Okay.
in view of that, my lord, I kindly allow me to withdraw with the liberty to approach the tribunal, my lord.
Okay. Part, Mr.
P. Yobin.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that pending disposal of this writ petition, the state respondent has already notified the district in sessions as UPI as the election tribunal.
Yes, my lord.
Election tribunal. And as such, he has the instruction to withdraw this petition. And he also submits that liberty may be granted to the petitioner to approach the said tribunal by filing appropriate petition.
My lord.
Accordingly, taking note of the submission of learned counsel for the petitioner, this petition stands disposed of on withdrawal, granting liberty to the petitioner to approach the election tribunal by filing appropriate petition.
My lord. Much obliged, Lord.
Item number 20.
My lord, I just forgot, my lord, that in any limitations, my lord, can be condoned, my lord, because if at all, my lord.
Section 14 is there.
My lord.
There's a limitation act.
My lord. My lord, I got it. My lord.
Not necessary to mention in the order.
My lord, much
You can
obliged.
plead it there.
My lord, obliged, my lord.
May I please, Your Lordship?
Mm.
Lordship, exactly this case has been covered by section 14 of the Limitation Act, my lord. What happened, my lord, after arbitral award, my lord, my lord, against the arbitral award, my lord, section 34 was filed at Siliguri court, my lord.
Okay.
So there, my lord, they took so many years to, my lord, proceed with further, my lord. After that, my lord, the department, my lord, came to know that the jurisdiction is at my lord, Bomdila District Court, my lord.
Okay.
And subsequently, my lord, the file bail, my lord, that arbitration application under section 34 before the my lord, landed court below. But landed court below, my lord, during the pendency, my lord, the other party filed, my lord, IA, raising the maintainability on the limitation, my lord. And accordingly, my lord, the landed court below, my lord, allowed the IA filed by the other party and saying that the petition is barred by limitation, my lord. If Lordship peruse the, my lord, the impugn order, my lord, is at, my lord, in IA, my lord, even not in the my lord, main case, my lord.
Okay, page number?
Page number, my lord, 149, my lord. Para 18, my lord. 18, 19, my lord. Therefore, in absence of the application under section 14, Limitation Act, I find no reasons to exclude that I am taken in the proceedings in the wrong court at Siliguri, my lord. Accordingly, the applications filed by the opposite parties under section 34 Arbitration and Conciliation Act 1996 being barred by each subsection 3
is not found to be maintainable in all aspects. In view of the foregoing discussions, this interlocutory application stands allowed and disposed of. Consequently, the delayed applications filed by the opposite parties under Section 34 of the Arbitration and Conciliation Act 1996 being registered a civil appeal number so and so is hereby rejected. This is the the impugn order. So,
Lordship, may I submit your Lordship? I am appearing for the first time, your Lordship. Just recently I have filed Wakalatnama. So at least a week time may be given so that I can prepare and argue on. Only 1 week, your Lordship. And I'll also file objection. Since Lordship, here the matter was settled before the Lok Adalat also, Lordship.
What happened?
On the consent
after
of
this
the
impugn order, after this impugn order,
There is no allegation of fraud, nothing.
matter was sent to the Lok Adalat. In the Lok Adalat, what happened? The unauthorized representatives of the department just go and attend it,
Nothing.
without having financial delegates. There is a
Maybe can anybody from the department can appear and say that the department has agreed to the.
No, that instruction was not given. He was forced to even give his signature. But from the records, it is very difficult to show before this honorable court that.
Okay, that is on the merit of the matter.
Correct,
Now we are not on that.
Yes, madam.
We are on this Section 34 application.
Yes, madam. No, madam.
So the question is, the court has observed that an application under Section 14 of the Limitation Act no, in absence of application
Yes,
under Section 14 of the Limitation Act, you
Madam-
did not file the application.
My respectful submission is, admittedly that the abandonment was not made in the appeal application under Section 34. But what I'm trying to point out is in the such proceedings, Section 14 is not required to be even pleaded, as because this is a law point, it has to be considered in separate way, in the judicious way, though that is not taken into consideration. That's aspect only, if the matter is remanded back to the learned court below again for fresh consideration, no prejudice will cause to anybody, It is the interest of the both the parties,
Since they are praying for interim, your Lordship. Is it?
Yes.
In that case, your Lordship, next week I'll be prepared and I'll argue on that.
On the last occasion,
Because as per the arbitration, they have to file one separate application, Section 36(3), for stay of the.
Then let him file objections. We'll see.
And my objection is ready for, yes.
Mr. Kato, learned counsel for the petitioner. Mr. A.K. Singh, learned counsel for the respondent. Mr. Singh submits that he has recently filed Wakalatnama and he tries for granting him 1 week time to file objection. In this application, parallel of recessal is the matter on. We will fix the matter on. Suggested that.
A week time.
Week time.
Yes, ma'am.
On next
The
Monday.
convenience of the other party.
Next Monday.
My lord.
Okay.
Another thing, on the last occasion, the interim period will be considered on the next date, So, that period maybe
File objection.
that observation will
Your
be made.
prayer is to remand the matter to the trial court.
Madam.
We'll see.
On 30, your Lordship?
Yes.
Yes.
Madam.
Without okay. If your prayer is to remand the matter for fresh consideration,
Madam.
we'll consider on that day.
But subsequently, before the Lok Adalat, the matter was also settled on the consent of the respondent.
That is also, in another aspect,
Because-
First of all, the application has to be considered on
They have
its own
sought-
merit, Then
They
after
have
my lord,
sought-
the settlement in the Lok Adalat will be another separate
Okay.
my lord, issue.
Item number
Deep
21.
Well, in this contempt petition,
Mm.
I am appearing for respondent number 1, 2, and 3.
Mm.
And already read appeal has been already filed. Read appeal number 33, 2025.
Before this court?
Before this court only.
Okay.
So this outcome of the contempt petition will be after the judgment of the read appeal matter. So let it come on 11th of May. It will come shortly for hearing.
11th of May.
Yes, my lord.
Okay.
I am appearing for respondent number 1, 2, and 3.
Okay. Heard, miss? Your name?
Excuse me, yeah, big.
Learned counsel for the petitioner, and Mr. Y. Doloy, learned counsel for the contender number
1, 2, and 3.
Mr. Doloy, apprise this court that the respondent number 1, 2, and 3 has already
The read appeal number is
read appeal
33, 2025.
being read appeal number 43 33 of 2025. 2025, and same is pending for hearing before the division bench of this court, and accordingly he applies for listing the matter on 11th of May. Fair allowed, rest shall list the matter on 11th of May.
Obliged.
Obliged.
Item number 22.
Yeah, my lord, petitioner was supposed to file rejoinder, my lord.
But petitioner is absent.
Yep.
You are appearing.
Lordship, I'll be appearing on behalf of T.T. Thara. T.T. Thara. Yes.
So when the rejoinder, who is supposed to file a rejoinder affidavit? The
Petitioner,
petitioner?
Lordship will need some time, Lordship.
Need some time. Heard Mr. Zini, learned counsel for the petitioner, and Ms. Wangmo, learned government advocate for the respondent number
1 to 4, my lord.
1 to 4. 1 to 4.
Service matter.
You have not filed the affidavit regarding dusty service also.
Lordship, I'll take the instruction and
Available.
we'll do it, Lordship.
Office note dated 20th/3/2026 indicates that affidavit regarding proof of dusty service upon the respondent number 7 and 8 has not yet been filed. Mr. Zini, learned counsel for the petitioner, submits that the instructions are awaited, and he prays for listing the matter after
2 weeks, Lordship.
after 2 weeks. They are allowed. Rest is list the matter after 2 weeks.
Item number 26.
Yes, ma'am. Lordship, in this matter, Lordship, only
Service not completed.
private respondents, they are appearing, Lordship.
We may be given some time to file the affidavit in opposition.
You have for respondent number
5 to 6, 5 to 12.
5 to 12.
Yes.
You have for 1 to 4.
1 to 3, lordship.
1 to.
Instruction was sought for, Lordship.
I need some time, your lordship.
Heard Mr. Zini, learned counsel for the petitioner, and madam, your name please?
Somu.
Learned counsel for the respondent number 5 to 12, and Ms. R. Basar for respondent number 1 to 4.
Your lordship, it's 6 to 12, not 5. Private respondent 6 to 12.
Five is also private respondent.
But we haven't given any instruction.
No
for five.
instruction. 6 to 12.
Yes, sir.
6 to 12. Neither edit card nor answer notice in respect of service of notice upon the respondent number 5 is received by the registry. So list the matter after 2 weeks, awaiting service report upon respondent number 5. In the meantime, the learned counsel for the respondents number 1 to 4, no 1 to 3. What about 4? Union of India,
Lordship,
Ministry of Defense.
Mr. Kato is supposed to represent, Lordship. Lordship, they are in fact performer respondent only, Lordship. They have already deposited the amount, Lordship. The issue here involved is, Lordship, compensation amount that was passed in my favor. I am the beneficiary of that particular land compensation matter, Lordship. Now, on the basis of the representation filed by the private respondent, they are not paying the compensation amount. That is only the issue involved in this case, Lordship. Entire acquisition process completed, Lordship. After entire process was completed, they simply filed one application before the Deputy Commissioner, disputing the title. And in fact, that title was already decided in several kavas that was passed, Lordship. Orders I have annexed also, Lordship. Small issue is involved here, Lordship. So they are, in fact, the Government of India is, Lordship, performer respondent, Lordship. In fact, Mr. Kato will be represented.
Since here, Union of India is arrived as a respondent number 4, you have to effect service of notice of appointment.
Lordship, in fact, Mr. Kato is supposed to represent, Lordship.
Okay, you
I've served the
inform
copy also.
him on next date.
Correct.
None appears for the respondent number 4 is not represented. Though the learned counsel for the petitioner submits that Mr. Kato, M. Kato, learned Deputy Solicitor General of India, is supposed to represent the respondent number 4. List the matter after 2 weeks. In the meantime, the respondent number 1 to 3 and 6 to 12 may file their affidavit in opposition.
Item number 27.
Lordship, can I have a fixed date, Lordship? Because in small issue is involved, Lordship.
When?
Second April.
2nd April. Obliged.
Item 27 and 28, my lord, we have filed our affidavit. It's regarding tender.
Tender.
Private respondents has not yet filed their affidavit, Lordship.
Who is it
It's been
representing?
multiple
Private
occasions fixed for filing of affidavit, Lordship.
No, my lord, in item 27, my lord, I'm representing respondent number 6. And in item 28, my lord, I'm representing respondent number 5. I entered appearance for the first time on 10th of this month, man. But on that day, I was out of station due to my sister's wedding. So we had in fact sought for some longer time to file our affidavit, man. But on that day, this matter did not reach, man. This honorable court could not take it up, man. Now, today, my lord,
File it now.
yes, I would like to pray for 3 weeks time to my lord, file.
Lordship, it will be too long, Lordship. It's a tender matter, Lordship.
Sort that 10 days.
2 weeks, my lord, at least, my lord.
Is there any stay order?
No, that's why, Lordship. Because it's a tender, if the entire work is
at least in
done
2 weeks time,
by the
maybe
private
granted,
respondent,
in the
because
meantime,
they are
we'll file our
enjoying,
affidavit, man.
we are challenging the work order issued by the
Okay. Heart Minister, your name, please.
T. Bagang, Lordship.
Learned counsel for the petitioner, Mr.
J. Kaba.
Learned counsel for respondent number.
Respondent number 5 in item number 27.
Respondent number 5 in item number 27 and
Respondent number 6 in item number 28.
respondent number 6 in item number 28. 28, Mr. D. Soki, learned counsel for the respondent number 6 in item number 27 and 5 in item number 28. And Mr. N. Roton, learned additional advocate general for the respondent number 1 to 5. 1 to 4. 1 to 4. Mr. Roton submits that the state respondents have already filed their affidavit in opposition. Mr. Soki, however, submits that he may be granted 2 weeks time to file counter affidavit. You have filed?
Your Lordship, in item number 27, I may be allowed to file affidavit in opposition.
The learned counsel for the respondent number 5
Yeah.
in item number 27 also tried for granting him time to file affidavit in opposition. We are allowed to
Lordship, it can be on 10th of April.
10th of April.
Yes, fixed date may be given, Lordship.
10th of April.
Yes.
Okay, all right.
So it will be
10th
2
of
weeks.
April.
Yes.
10th of April.
It's more than 2 weeks, Lord.
10th of April.
Obliged, Lord.
Item number 29 and 30.
My lord, for respondent number 5, the executing agency. They have an IA, my lord, over here.
I is for?
My lord, IA was for stay of that construction was especially this rate petition is for the transmission 132 kV transmission line. So the respondents, especially the power grid, they were constructing in the private land of the petitioner without giving any notice, and they were destroying the properties, especially the Jirats, crops and plants. So we have filed IA to stay to restrain, do any activities before the recording of the properties, especially which is attached to the land which is being taken up by the private respondents. Now, well, in this case, there was a direction, my lord. I will just take to the last order, my lord. Order dated 12/2. 12/2, my lord. May I read last paragraph, my lord? While at this stage, this court is not inclined to pass any interim order, considering the balance of equities, it is directed that before the construction activities are carried out, a proper survey of existing Jirat and the status of land is done and recorded. That was a direction, my lord. Now, in some cases, they have recorded, my lord, while doing the activities, especially for the installation of the towers in the lane of the petitioners, they have recorded by the private respondents and by the governments. But then they have not assessed, and then they have not paid the compensation, my lord. There is two compensation. The one was assessed early in 2023, but then lane was not taken in possession. So it was in possession of the petitioners. It is full of gardens, my lord. It's betel nuts, trees, and oranges, and in some places some structures. So they were destroying without assessing the while doing the preparing for the installation. So direction was that they should record and
Already recorded. So,
In all the parcel of land.
Yeah.
In
We have
fact,
already made that exercise even prior to starting out the construction. Whatever properties are supposed to be destroyed or all have been made. The drafts have been prepared. Now we'll be filing our affidavit. Only issue here for your lordship determination is that these are petitioners who are residing inside a reserve forest, and they are Changmas and Hajams. Now, whether these illegal settlers within the reserve forest will be
Mr. Roto, in this petition, we are not going to determine whether they are illegal or legal occupants.
In fact, the issue is that we have determined everything. All what properties are going to be destroyed, what are the existing garage and all. Now, the main issue, contention before this honorable court will be the land in which they are settled is within a reserve forest. First. And on top of that, they are illegal settlers.
No, okay. Let us do one thing.
So that's why
yes, my lord.
My lord, I
am filing our affidavit, my lord, to that.
I will just take to the affidavit of
the executing agency in this project. Now, my lord, we do not do any land acquisition. Now we take possession of the land. Once we have set up our tower bricks and the stringing, the transmission system,
they are free to use the land. Now, that being the actual and factual position of law, my lord, in the IA we have filed an affidavit. If I could have my lord's attention to my affidavit, my lord.
No. You see,
We have
here,
done the assessment.
No. In this application, his pair is the verification of the Zirat.
Jirat, yes,
And Zirat and only Zirat.
Yes, my lord.
Only Zirat. And as per the submission of Mr. Ratan, they have already carried out the verification and recorded the Zirat.
Yes, my lord.
My lord will see
If that means so,
After the order, my lord.
after the order.
Yes, my lord.
So in that view of the matter, this IA become infructuous now.
Yes.
My lord.
In fact,
Yes, my lord, yes. Yes, my lord. But then my stress is that, my lord, as per this IA, they have recorded that no issue, my lord. The matter, yes. We will not be stressing on the IA, my lord. Yes. But in the main petition, my lord, I will just reply to the additional age.
In main petition or
That will be on, my lord, that will be on merits. My lord, the core issue is that the assessments have been done since long time ago and we continue to do it as we go ahead. Page number 68 onwards, in my affidavit, my lord will see we have annexed the assessment of Zirat and that of the right of way. Now, my lord, we as an agency, we cannot determine the legality or illegality of somebody who is competent to receive or not receive the compensation.
Yes.
That is for the state to decide. From our end, we are doing a construction. We have done the damage assessment. We have recorded it with the valuation and the rates as have been prescribed by various agencies of the state, my lord. Now, my lord, this I humbly pray, my lord, that this question, whether they are entitled or not, my lord, there is assessment, there is entitlement, there is payment, and then there is satisfaction or dissatisfaction. If they are not satisfied with the quantum, law has provided a mechanism for them to go and agitate it. Not this forum, a separate forum, my lord, under 16(3) of the Telegraph Act. But for that, they will have to be entitled. My lord, whether they are entitled or not entitled, we as an agency, we cannot state. It is for the state to state. But if they are entitled, the assessment is already done.
Okay. In the main petition, whether you have filed your affidavit
in both, my lord. Main also I have filed.
to file our affidavit.
State has not filed, we have
Therefore,
filed.
we are seeking some.
Okay.
So, my lord, IA we closed because the assessment is on record and the issue we kept.
Okay. Mr. Mao has already agreed that he is not going to press this IA.
My lord.
So why you are submitting on this point then?
So, but then let them file affidavit and bring on record that after this court direction, they have the recorded the Jirats, my lord.
But it's already on record by my affidavit. I have done.
No, that was in 2023 was different, my lord. That was not, they have assessed, no doubt, but then land was not taken in possession by the respondent authorities. But recently only they were doing the construction. And on the basis we file IA praying that this Jirat has to be recorded, and accordingly as per the additional AG, he's submitting that it's been recorded, and let him file the, let them file the fresh affidavit stating that they have freshly recorded after this IA's direction.
The interim order says that before construction, the Jirats has to be recorded. That is the order. It did not say that you have to record it afresh. Our instruction is that we have already recorded.
No, but then we are able to show that construction was. I will just show in IA, my lord. IA, my lord, we have shown the pictures with the date, my lord.
No, Mr. Ratan.
Yes, ma'am.
Whether the assessment was done after passing of this order dated 12/2/2020.
No, it was done earlier. This assessment, this order has said that before starting the construction, you have to. We have already done the assessment long time back.
Okay, then we will not dispose of this IA.
Yes, my lord.
We will hear both the matter together.
Let them file affidavit.
My lord,
yes.
my lord, I have latest instructions that as we are doing construction, also we are doing assessment.
Yes, yeah,
we are abiding by the order.
Okay.
We are. And if I can produce it as I...
Let them file, my lord.
As I...
Respondent.
File our affidavit.
Yeah. Even the...
Finally, we hear and dispose of both the matter together. Heard Mr. Mao, Learned Counsel for the applicant stroke petitioner in IA number 45 AP 2026 and WPC number 202 of 2025. Mr. Khera for respondent of
Five, my
party number
5.
5 and Mr. Ratan for 124. Learned additional advocate general for the respondent number 124. 124. Mr. Khera submits that he has already filed affidavit in opposition in both the IA and
The writ.
petition. However, Mr. Ratan, learned additional advocate general, submits that he may be granted some time to file the affidavit in opposition in both the matters. They are allowed. Recessal is the matter on.
My lord, in repetition, I'm for 1, 2, 3. He is for 4.
Read petition 1 to 3. Okay.
My lord, actually what they have done is in the IA, my lord, as an officer of the court, I'll have to bring it to my lord's attention. In the writ petition, they have 6 parties. In the IA, they have added a party. In the IA, there is a party who is not a party in the writ.
Yes.
Against whom they
it should be.
My
lord, against whom they seek direction.
My lord, that one, my lord, I will pray that can be struck out, my lord. Especially wrongly it is. We have implemented one extra assistant commissioner
In
They-
the
in the IA.
petition.
That may be struck out, my lord.
Read petition.
In
No,
IA,
in
my
the
lord,
IA,
not
IA,
in the writ.
IA, my
The
lord.
writ petition, that is there. He is extra assistant commissioner is already there. The additional deputy commissioner has been added in the I.
So, my lord, that we will pray that can be struck out, my lord.
3. Respondent number 3.
Yes, in the I.
3, my lord, in the IA.
Mr. Mao, learned counsel for the applicant in I number so and so submits that the name of respondent number 3 may be struck off as he is not a necessary party in this I. Accordingly, taking note of the submission of learned counsel for the applicant and at the cost and risks of the applicant, the name of respondent number 3 stands struck off from the array of this application. In view of above, Mr. Mao shall file amended cost title in the I number so and so before next date.
Yes, my lord. My lord, I just, my lord, I may just, affidavit, respondent number, Power Grid, they have filed affidavit, but it doesn't include this one, recording of the assessment after the Your Honorable Court's order, my lord. Then let them file a fresh affidavit showing that how much property has been recorded by during the construction, my lord. Let them file a fresh because it doesn't include in the earlier counter affidavit filed by them.
No, who has to carry out this assessment and verification? The state?
My
Yes.
lord, it's a joint committee.
Joint, my lord.
committee which does.
Joint committee.
My lord.
So
we are a part
Your-
of the.
your
com-
affidavit is silent on that point.
Yes, my lord.
My lord, in my affidavit, I have already stated that we have done the assessment. I have attached the assessment sheets.
But that is up to 2020.
If my lord peruses page, if I may have my lord's attention to page
After
60.
after the interim order, whether it was carried out or not.
Yes, my lord.
Yes, that's what.
After the interim order, it was carried out.
Yes, my lord.
But you have not incorporated in your affidavit in opposition.
My lord, these were developments subsequent to my filing of the affidavit.
So you file a fresh affidavit then.
My lord.
Yes,
my lord.
Okay. Mr. Mao, learned counsel for the applicant in I number so and so has pointed out that after the interim order passed by this court on 25,
12 to 2025.
12 to 20,
5, my lord. 26, my lord.
26.
12 to 2026. 12 to.
26. কি বলে start করলো? The affidavit in opposition filed by the respondent number
My lord,
IA in IA.
IA 5 after they rectify
Five,
4.
respondent number
5.
5.
respondent number 5 has not no, though the respondent number 5 has filed the affidavit in opposition, yet the same, in the said affidavit, the respondent number 5 has not incorporated the damage assessment and zigat recorded after the verification being carried out as per direction of this court dated 12 to 2026. Mr. Khera submits that he had filed the affidavit before the direction issued by this court on 12 to 2026.
My lord, I filed it after the directions, but then these were new developments. So
Okay.
in my affidavit, I did not.
In that view of the matter, Mr. Khera is directed to file a fresh affidavit incorporating the zigat
Yes, ma'am.
recorded after the verification carried out pursuant to the order of this court dated 25 to
12
12 to
12
2026.
26.
list accordingly.
My lord, that part be rectified. I filed it prior to the direction.
Okay, we already recorded it.
Obliged.
Item number 33.
Lord, can the matter be listed on 28th of April? 27 April?
27, I will be out of station. After 6, नहीं, बाहर में. 6 to after 6 April.
No, 27 April.
I will be out of station.
My lord, can we on a common date, because I'll be traveling from outside. So can we fix a common date and give it to the court master?
When?
April, my lord. April, second week of April, my lord.
Suggested date.
27
April.
April 9.
9th of April.
No, I will not be in the country. I will not be country.
So you just fixed after April. After 9.
My lord, 9. Holiday. 27
April.
27.
Okay. Let's establish the matter on 27th of April.
Obliged.
Highly obliged, my lord.
I am petitioner in person. I filed the affidavit, additional affidavit. In additional affidavit, I was promoted. I was promoted as a professor in 2023.
You have filed additional affidavit.
Yes.
When?
Yes. Because I did not get eligibility.
Pardon?
Date of eligibility. They have given me date of interview. They promoted me on the date of interview. They did not promote me date of eligibility.
Okay. You are for the university.
Lordship, I'm for University, Rajiv Gandhi University, Central University.
Pardon?
Rajiv Gandhi University, yeah.
Yes.
Respondent.
Ready to argue the matter?
Yes, sir, I'm ready. Lordship.
Ready?
Yes. Otherwise, last time he has filed one this additional affidavit. So I seek a time to file a reply. So in the meantime, otherwise, Lordship may give me the 1 week time.
No, the question is whether you are really interested to file a reply to the additional affidavit filed by the petitioner.
Actually, that document, that document they have taken, the university. So they have, I have to update that document and file. Otherwise, this case, nothing is there, Lordship. Already he is serving as a professor. He was seeking a retrospective effect that he joined in university 2015. Then he is seeking for promotion from retrospective effect from 2018. So we have appointed him as a professor 2023. So now he is serving as a professor. Just he's seeking that from that of this eligibility. That of eligibility, he should be promoted to the professor, from associate professor to professor. And the date of joining in the university, he joined Lordship on 6/8/2015. He joined, and thereafter he filed application for promotion to under CAS scheme, Career Advance scheme, as a professor on 15/6/2018. So thereafter, the screening committee rejected his application. He was disqualified. Disqualified his application because he was not pulse and rejected by the committee on ground of incomplete application form of the UGC as per UGC 2016 dated 30/4/2020. Lordship. Then second application he filed for promotion under CS filed on 2/9/2022. 2/9/22. Then Lordship, what happened? That is page 69 of my affidavit. Then appointment order was made, appointed to him as a professor. Consider his case. We have considered his case. That is 24 to 2023.
From the date on which he is entitled to the said post.
No. From the date of from the qualifying, because though he is eligible from the eligible year, but he has to pays an interview. But he pays the interview and his document was incomplete because he could not secure a.
Yeah, you could not give the retrospective effect.
No. We could not.
It is
We could
prospective.
not. Prospective only.
From
That
the
is
date of facing the interview.
yes, Lordship. Yes. This is the main issue. And now he is serving since 2023 as a professor in education department. And he is seeking the retrospective effect of 2018, which we cannot consider because he was disqualified during the interview by the screening committee. And appointment order dated 24 to 2023.
Whether to entitle the benefit of case.
Yes.
He has to face the interview.
Yes, sir. There is a UGC norms. UGC guidelines is there. He has to face an interview. He has to fulfill the criteria.
Okay.
Which like PhD, like research scholar, he has to give us that all this. There is criteria. For that he has to qualify, and on that ground his application was rejected. He could not secure cross all those criteria. So rest of the candidates, those who falls under the CSP scheme, they were promoted. But his considered not his case was not considered because his application was incomplete due to incomplete and ineligibility, inability to promote it as a professor in education department. So now, Lordship, and his case was considered 24. Now come to Lordship. I'll just give my in my affidavit.
Sir, I want to speak few words. Can I speak?
Yes.
Sir, I was promoted in 2023 in the, for the date of interview. After that, after 6 months, again interview was held. Interview had 9% seat in the interview. Again, University Authority gave them date of interview. Not date of eligibility. They do hesitation. They talked with the executive council. They consider their case. I have brought all their documents. Sir has told me, Honorable Justice Kamlesh Ade, he told me, bring all the papers of nine persons. Sir, you can see, sir.
So pursuant to this order, you have filed your additional affidavit.
Yes, sir.
Okay. You have brought on record the 61st of meeting of the Executive Council.
Yes, sir. Honorable Justice Comrade Hate.
No, that's all right. But where is the resolution? Is it resolution number?
61.
61.4.
Yeah.
Is it?
Yes, sir.
So whether this committee was constituted?
Yes, sir.
Constituted.
Yeah, yeah.
Whether they have submitted the report?
Yes, sir. They submitted.
Where is that report?
Sir, I shall tell you, sir. Page number 220, 220.
Pardon?
Page number 220.
220.
Yes. EC 23.15.
20?
63.16.
16.
Yes. Ratification items, action taken by the University Authority. Next is the power provision, Rajiv Gandhi University, 2007, under status of this Photobank financial fair.
$220. 63 point, is it 63 point?
Yes, Stephen, sir.
One six, it is a different matter.
$219, sir.
19.
219.
No, no. As per this resolution, EC 63.12,
Yes, sir.
a committee is constituted.
Yes, sir. Yes, sir.
Whether that committee has submitted the report.
Sir, I tell you, sir. Page number 2020. The Executive Council pursued the matter, resolved that in conformity with the GC regulation, data of eligibility would be given would be date of date of promotion for
Page
above
number
mentioned faculty.
2020.
Yes.
Okay. EC
This-
resolution number?
Resolution number AC 63.12. 12.
12.
Yes. Page number 20, 220, decision. Executive Council pursued the matter and observed that in conformity with the UC regulation, date of eligibility will be the date of promotion. Page number 220.
Yes.
Decision. The Executive Council pursued the matter and observed that in conformity with the UC regulations, date of eligibility would be the date of promotion. For the faculty member.
Yes. Have you seen this page number 224? 224. Of the additional affidavit filed by him? Annexure 4 series.
Also, this I have submitted this document to the university for instruction. But in this case, Lordship, here, as per in my reply affidavit.
No, okay. First, you see, as per this page number 224, this professor, Dr. Miyazi Hazam,
Yes.
Associate Professor, Department of English, has been promoted to the post to the professor under case with effect from 4 to 2021, date of eligibility.
Lordship.
So why the similar benefit is not granted to the petitioner?
Lordship, see, they have
Because
also faced the interview in the screening before the screening committee.
Sir, I have.
This is the usual process.
I have filed a petition. That's why they.
All appointment order was made after qualifying. After qualifying the screening before
from the date of eligibility.
Eligibility.
But Lordship, here in my affidavit, page number 11, the clause 6.3, subclause 6 of Roman 3 clause. Again, the candidate who does not succeed in the first assessment, he shall have to be reassessed only after 1 year. When such a candidate succeed in the eventual assessment, his her promotion shall be deemed to be 1 year.
You see, here, this person is promoted to the post of professor as per the 63rd Executive Council meeting.
They
63rd. Executive Council meeting held on 18/9/2025. EC 63:12. So there's a persons, all total 9 in number. They have been given the benefit of case with effect from the date of their eligibility.
Yes, sir.
So similar benefit may be granted to the petitioner also.
Lordship, for benefit, obviously, but for retrospective promotion, we can't do that. Retrospective, he was seeking retrospective.
No. You see, whatever benefit is granted to these professors, he is also entitled to that.
Lordship, that's true. We have, but.
So when you became eligible
Yes, sir.
for this case benefit,
18.
Pardon?
6 August 2018.
6 August 2018.
18.
So where is your promotion order?
2023.
Is it part of the record?
Yes, sir.
Page number?
Yes. Yes. Yes.
So in his petition,
Yes, sir.
page number
In
75.
75.
Page 75. Annexate.
Page number 75.
Right.
So your date of eligibility is
6 August 2018.
6 August.
6 August 2018.
So if similarly situated persons are granted the benefit of case from the date of their eligibility, why the petitioner is not granted the same benefit? You better you do one thing. You have gone through the additional affidavit.
No. That's affidavit I have submitted to the university.
You have not gone through the affidavit.
Not gone through. So
Okay. You see, his additional affidavit, page number 219. This EC resolution number 63.12. 63.12. Their decision has been taken. To extend the benefit and thereafter from Annexure 4 series, page number 224 up to 232. These are orders passed on the same date, that is 24th of October 2025, whereby some of the professors have been granted the benefit from the date of their eligibility. So why the petitioner should not be granted similar benefit? So you obtain instruction on this point. We'll take this matter on Wednesday.
Wednesday.
ठीक है
Wednesday.
Wednesday
Wednesday.
okay
Wednesday.
Wednesday
Day after tomorrow, sir.
Day after tomorrow.
yes
Today is Monday. Okay. Heard. Dr. Satish Kumar, learned no, petitioner in person. And Mr. Your name, please?
R. Nabam.
R. Nabam. You are still the secretary of that bar?
No, I am president here now.
Here?
Yes, Lordship.
Okay.
Recently elected.
Recently?
Yes, sir.
Mr. Tada is not the president.
He his hand over.
Term is over.
Term is over.
Okay. Mr. Nabam, learned counsel for the respondent university. Mr. Satish Kumar, learned the petitioner in person, referring to the minutes of the meeting of 60 minutes of the meeting of 63rd EC dated 18/9/2025 submits that in the said meeting, Executive Council has taken a decision to extend the benefit of case to some of the similarly situated person with effect from the date of their eligibility. And pursuant to the said EC resolution, the register of the university has passed orders on 24th October 2025 extending the benefit of case from the date of their eligibility. And being similarly situated, he also entitled to the similar benefit. In that view of the matter, Mr. Nabam, learned standing counsel for the respondent university, is directed to obtain instruction from the respondent university as to whether similar benefit may be granted to the present petitioner also. List the matter on Wednesday as fixed item.